Good morning. Now that the room's a little quieter, we're just before 9 o'clock, but we can get started. I have some opening remarks to read into the record in any event. And welcome. Please, before we get started, please turn off your cell phones or put it on an etiquette feature. And please be advised that today's hearing is being live streamed on YouTube as part of an ongoing pilot project. So hello to everyone out there in YouTube land. Okay, this meeting is held in accordance with sections 45 and 53 of the Planning Act as amended. I'll now call this meeting of the Committee of Adjustments for the City of Toronto to order. The Committee of Adjustment considers applications for minor variances from the provisions of the zoning bylaw, permissions to extend or alter lawful non-conforming uses, and consents to create new lots. To ensure a fair and timely hearing, I will vet the agenda to determine which applications can be dealt with immediately and which applications require a more in-depth review. I'll call each item in the order listed on the agenda by its municipal address and first ask if the applicant or agent is present. Just put up your hand, let us know you're here. And then I'll ask if there's anyone present in interest that wishes to address the committee, if there's any neighbors present. If there are people in interest, those matters will be held until the end of the morning agenda, until all the non-contested applications have been cleared from the agenda. If your item is held, we strongly recommend that you meet outside with the concerned neighbors in an effort to either understand the application, get some clarification, resolve or narrow the issues. If no person is present, the agent or applicant proceeds with their presentation if required. The committee may ask questions and/or then take the matter into the committee for decision. On a very straightforward application I may just ask if the committee members feel they need a fulsome presentation, or if we can just see if they have any questions for the applicant rather than having them do so. And each speaker, including the applicant or agent, is given a maximum of 5 minutes to address the committee. Mr. Nipfel will be watching the clock. If something's very complicated, we may ask you to enable you to go on a few minutes longer, especially if you're interrupted with questions from the panel. So when you address the committee, please come forward to the podium and state your name clearly for the record. Please also hand in the white decision request card, which are, I believe, on the placards, under the placards at either sides of the room. And then go up to the podium, state your name clearly for the record. And if you have a written submission that you're reading from, please leave a copy with staff before you leave. So if the applicant goes first, is given a maximum of 5 minutes to present the merits of their application. Then individuals either in support or opposed to the application will be given an opportunity to express their views. If there are several speakers present on a given application in opposition or with concerns, we ask, if possible, to appoint a spokesperson to present the common views of the neighbors. We want to hear your views, however, covering the same points will not advance your cause. Of course, if the spokesperson hasn't mentioned something that you feel is of importance or you have unique concerns from your own perspective, you'll certainly be allowed to speak, but we don't want you to cover the same points ad nauseum. Committee members may ask questions of each speaker at the end of their submissions, and then when all speakers are finished, the applicant will be given an opportunity to rebut only those related issues that have been raised by the neighbors, not to rehash their application, but just to answer any questions or concerns that have been raised by the neighbors. The matter will then be taken into committee for a decision. This will mark the end of discussion on that application. Please also remember to confine your remarks to the matters outside than the application. We deal with planning matters here. We don't deal with personal issues between neighbors, and we don't deal with building issues or concerns. The decision. If you don't agree with our committee's decision, you may file an appeal. Almost all appeals are now dealt with by a tribunal called the Toronto Local Appeal Body, or TLAB. And for more information on TLAB, please visit their website or the Committee of Adjustment website. Appeal instructions will be included at the bottom of every decision, and in order to receive a copy of the committee's decision and to be informed of appeal proceedings, you must fill out one of those white decision request cards and leave a copy with staff. And please remember to include your email address on that form, as TLAB will be sending notification and updates by email. Decisions are mailed out within 3 business days. Now some preliminary matters to take care of. First of all, to confirm the minutes of the last meeting, which I believe was February the 27th. Madam Secretary Treasurer, do we have a motion for approval? Okay, Ms. Hayes was not here, so I'll second that. And minutes are approved. Okay, declarations of interest on this morning's agenda. I have a declaration on the item number 125 Lamport, as I'm acquainted with one of the neighbors. And anyone else have any conflicts of interest to declare on the morning agenda? No. Okay. Okay, we have, I understand, 2 files to be closed. So we'll deal with those. The first one is 234 Ashdale. Is anyone here on 234 Ashdale? It's not on the agenda. Okay, this is a request to close the file. Okay, I don't believe there's any. Is there a request for a fee refund or no on this one?
Not on this one.
Okay, so in the matter of closing the file?
I'll put forward a motion to close the file with no refund, due to withdrawal.
Okay, matter is passed. Okay, and the next one is 37 Kildonan Road. Anyone here on 17 Kildonan Road? This again is a request to close the file, and in this one there is a request for a refund from Compassionate Grounds. We have a motion.
Mr. Chairman, I put forward a motion to close the file, but I don't understand the reason for the requested refund in there, so my motion is without a refund.
Thank you.
I'll second that.
Okay, that's passed. Thank you. Okay, does anyone here this morning wish to withdraw their application? Okay, and I guess we can deal with deferral requests as we go through the matters. Okay, so I'll now vet the agenda. Item number 125 Lamport Avenue. Is the applicant here? Please raise your hand. Any neighbors present on 25 Lamport? Yes, okay, so that matter will be held, and we recommend, if possible, if you'd like to have a discussion outside the room while we do the other applications, that is sometimes beneficial. Okay. Item number 2, 162 CEDRIC Avenue. Applicant agent, thank you. Any neighbors present on 162 CEDRIC? No, it will not be held. 66 HARPER Avenue. The applicant here, thank you. Any neighbors present on 66 HARPER? Okay, that matter will be held. And if you, Mr. Binkowski, if you want to look up, I don't know if you want to have a meeting outside the room with the neighbors, if you haven't already had fulsome discussions. Okay. Item number 4, 592 Northcliffe Boulevard. Applicant agent, any neighbors present on Northcliffe Boulevard? Okay, that will not be held. 447 WINNETT Avenue. Applicant, any neighbors here on 447 WINNETT?
Yes.
Yes, the matter will be held. Do you want to stand up again and put up your hand? And agent or applicant, you want to put up your hand? I don't know if you want to have a discussion, if you haven't already done so. You're here in opposition, correct? Okay, thank you. So you may want to meet with the applicant and have a discussion. Okay, so WINNETT will be held. Item number 6, 5, or was that number? That was number 6, 5, right?
That's number 5, yes.
Okay, number 6, 525 Ossington Avenue. Applicant, okay, I see the hand there. Any neighbors present at 525 Ossington?
Yes.
Yes, okay, that will be held. Do you see who the applicant is? I mean, if you want to have a discussion, you can. Item number 7, 1261 Bloor Street West. Okay, any neighbors present on Bloor Street West? 1261? No, it will not be held.
Mr. Chair, for item number 7, there's no folks here, but the agent has 2 other applications that are held.
Right.
I'm just wondering if 7 can be then dealt with after the 2 items that are being held, because he's going to be out discussing
Okay.
in the hall.
If you can just remind me when that, after.
So we're holding it then?
Okay, item number 8, 73 HOCKEN Avenue. Is the applicant or agent here on 73 HOCKEN?
Yes.
Okay, thank you. Any neighbors present on 733 HOCKEN? With concerns, comments? No, it will not be held. Item 9, 46 Borden Street. The applicant or agent here on 46 Borden Street. Oh, yes, okay, thank you. Any neighbors present on 46 Borden? No, it will not be held. Item number 10, 73 LYND Avenue. Applicant, agent, thank you. Any neighbors on LYND Avenue? No, it won't be held. 33 Whitehall Road, item number 11. Applicant, any neighbors present on 33 Whitehall? Won't be held. Item number 12, 57.5 Melville. Okay, agent, any neighbors present on Melville Avenue? Won't be held. Item 13, 19 Claude Avenue. Applicant, thank you. Any neighbors here on Claude Avenue? Won't be held. 14, 442 Margueretta Street. Is the applicant here on 442 Margueretta, item number 14? Okay, I'll just hold that with a little h. I guess they're stuck in traffic. Item 15, 196 Montclair Avenue. Applicant, agent, any neighbors here on 196 Montclair? No, okay, won't be held. 156 Chiltern Hill Road. Applicant, agent, thank you. Any neighbors here on 156 Chiltern Hill Road? No. Item 17, 168 Hillsdale Avenue. Applicant, any neighbors here on Hillsdale Avenue? Okay, lots of people. I don't know if you've had any discussions or not. You want to put up your hands again? I don't know if the applicant, agent, I don't know if you want to convene a little meeting here outside the room, but that will be held. Item 18, 36 Elgin Avenue. Applicant, agent, thank you. Anybody else here on Elgin? Any neighbors with concerns? Nope. 216 GLENAYR Road, item number 19. Applicant, agent, thank you. Neighbors on 216 GLENAYR?
Yes.
Okay, that matter will be held, and if you see, you want to have a discussion. And item number 20, 126A Glen Road. Applicant, agent. Okay, any neighbors here on 126A Glen Road? Okay, it won't be held. So just to recap the items that we're going to be holding and till the end of the time slot. Item number 1, item number 3, item number 5, item number 6, 17, and 19. Okay.
Is that the one where
14 was not here. 7
Seven's held just because Minkowski.
7 is held just because of Mr. Binkowski. Okay. Okay, so those of you who want to have a discussion, go outside the room. Otherwise, you can stay in here and watch the other applications. Okay, so the first application we're going to deal with this morning is item number 2, 162 Cedric Avenue. This is an application to alter the existing one-story detached dwelling by constructing second and third floor additions, a rear ground floor deck, and a rear second floor balcony. We have before us the materials filed with the application. We have correspondence from right-of-way management looking to we should refuse variance number 4, and we have a report from planning which talks about possibly missing a variance. You want to come to the podium, please?
Good morning, ladies and gentlemen.
Good morning. Can we get your name and address, please?
So my name is Pablo Reynoso. The office place, the address is 1050 McNichol Avenue.
Okay, so you're the agent, correct?
Pardon me?
You're the agent
Yes.
or the owner? Have you seen the planning report?
Yes.
Okay. They talk about refusing variance number 4 for the proposed side exterior wall height, but they also mention, just before we get into the merits of the application, they also note that a floor space index variance appears to be missing. They say that the application proposes an FSI of 1.15 times the area of the lot, whereas the zoning bylaw would permit a maximum of 0.8. Staff contacted the applicant in January to clarify and did not receive a response. So do you have a FSI variance that is not listed on your list of variances?
No, to be honest, no. They gave me the drawings, but no. But I'm assuming it was 1.05 if I'm not wrong. So it's a little bit higher than that.
You know, I can't hear you. You're sort of like mumbling a bit, or maybe stand a little closer to the app.
Okay, is it better?
Yes.
Perfect. Yeah, so according to the last time that I checked that, it was 0.01, the floor space index.
You're 0.01 over what's permitted?
No, it was 0.8. That was permitted.
So what have you got? 1.01?
1.05.
So you are, you do
I'm
need
still-
variance for floor space.
But it's not listed, so
Yeah, it's not listed. So probably gonna get
proceed with your application today. You're going to still have to come back with a new application because you don't have the floor space index is not before us. It hasn't been circulated through the notice, so we can't deal with that and grant you that because it's not listed as a requested variance.
Okay, so worst case scenario, you have to reduce the size of the house to match.
Well, yeah, you would have to build without a floor space index variance.
Okay.
What happened? Staff contacted or said they contacted you in January. You
They
didn't.
gave the information. And actually, the examiner called us 1 week ago asking, but he didn't ask for the floor space index. He just asked for the waiver for one of the variances. So yeah,
They
no.
wanted you to- They want us to refuse variance number 4, wall height, but you're missing the variance. So do you want to proceed today? That
Yeah.
means you wouldn't be able to build more than 0.8.
If we proceed that,
And
Which may affect the,
the design of the house and everything, right?
And the other thing is that the plans that we have before us, you won't be able to build these. They'd have to be altered substantially.
Sorry, say that again?
The drawings that we have that show what it is you're proposing, you won't be able to build this under the variances that you're requesting today if they're approved.
Yeah, I have to change this.
Yeah, so you're going to have to redesign everything anyway. And as my colleague indicated, by redesigning to meet floor space index, you might generate another variance.
And I have to apply for the second committee for the TLAB in this case, right?
no.
No, you'd have to come back and
Yeah, I have to come up for. Okay.
We're not appealing a decision that we made. We don't have anything here to make a
Mm-hmm.
decision.
And what's the process if I postpone the committee budget? I have to wait for the next hearing date and prepare everything for the next committee? Is that how?
You'd have to redo your variances when you're ready, and perhaps, I don't know if you proceeded on a waiver or a zoning review, then contact staff and they'll put it on the next available agenda. It may not be the next agenda, where our agendas are very
It's
full
really
and
tight,
some
so yeah, probably.
agendas are now closed, so you'd have to defer. But if you proceed today, you're going to have to make a second application, pay a second fee. So although this creates sort of a hardship on the committee because we have full agendas and staff does not like us to or defer applications, I don't see that we have any choice but to do that today, because if we proceed and even grant you what's before us, you're still going to have to come back and then make a second application.
Yeah, okay, let's.
You're not Mr. Battaglia? You work with Mr. Battaglia?
I work for him, yes.
Okay, because he's listed as the agent. Okay, committee members?
Mr. Chairman, I don't think that there's a reasonable alternative other than deferral. The application clearly has to be altered and reheard anyway, so I'm going to move deferral of the application for the applicant to redefine or reassess his application and include all the variances required.
Okay, and he'll obviously have to pay for the re-notification fee, because the neighbors will have to be sent out notices.
I see.
No problem.
Okay, so the matter's been deferred. Thank you.
Okay, thanks.
We'll see you back here another time.
Okay. Yeah, I can.
Okay, item 3 is held, so we'll move over to item number 4, which is 592 Northcliffe Boulevard. It's an application to convert the basement of the existing 2-story semi-detached dwelling into a dwelling unit and to construct a rear 2-story addition. There is only one variance, which is the one parking spot provided as opposed to 2 required because of the second dwelling unit. And we have a condition of approval from right-of-way management. Good morning.
Good morning.
Can you give us your name, please?
My name is Steve McCabe. My address is 592 Northcliffe Boulevard.
Okay. Have you read the report from right-of-way management?
I have not. I was not aware of it until now.
Okay. It's dated March the 14th. Applicant should check the file. Up to the morning of the hearing, this was, I guess, a week ago. So basically, they don't have an objection to maintaining the front yard parking space and condition. It's partially on private property, partially on the city boulevard, and licensed with the current owner. So the boulevard is required to be restored to the original license condition, which includes soft landscaping.
I'm sorry, I don't understand that. Are you saying I need to change my parking pad back to landscaping?
It says any alteration to the current location, size, paving material of the parking pad or front landscaping is not permitted without prior authorization. So you have to contact the off-street parking.
So I can't make any alterations?
Well, you just have to contact, if we grant you this approval, you have to contact them.
Okay, I understand.
Yeah. Okay. Would the committee members like a fulsome presentation, or just
I don't
see
need
if you have
a
any
present-
questions?
I don't need a
I don't
presentation.
need a presentation.
Okay, any questions for the applicant?
No.
Okay,
I'd
we're
like
ready
to
for
move
the
approval of the application, conditional on the right-of-way management request for consultation.
I second that.
Okay, you have your approval, thank you.
Thank you very much.
Okay, items 5 and 6 are being held, so 7 is being held for Mr. Binkowski, so we'll move on to item number 8, which is 73 Hocken Avenue. It's an application to construct a new 3-story detached dwelling with a front basement walkout, a rear front second and third floor decks, and a detached rear garage. We have before us a copy of staff report from Community Planning recommending refusal of variance 5 with respect to soft landscaping, and we have Urban Forestry requesting their standard conditions 2 and 3. Good morning.
Good morning, Mr. Chairman, members of the committee. My name is Nelson Espinola, here as the agent for the application.
Okay,
Beside me is the owner, Mr. HOCKEN.
welcome.
With regards to the staff report, we are aware that there is no basement walkouts on that particular street, but there is in the vicinity. My client here has taken some pictures of similar basement walkouts as we're proposing.
Okay, first of all, let's see if committee members want a presentation on this application. Okay, so anyway, if you'd like to make a presentation with respect to the issue of variance number 5 and the soft landscaping in the front yard, I guess that's occasioned by the front basement walkout, correct?
Yes,
Now, would you comply if you didn't have a front basement walkout, or would you?
we would comply.
Can I clarify, you indicated that there are no front basement walkouts on this street,
On that street, but
which is why planning is objecting.
that's correct.
So they don't want to see an addition, they don't want to see a new one and then have that created as a precedent.
Well, my feeling is that it has more to do with the fact that we're reducing the front landscaped area, but in our opinion, it is compatible to what exists there right now. Front landscaped areas in that particular street are very similar to what we're proposing.
Okay.
Is there ability to have the entrance to the basement on the side of the house or at the rear of the house, or do site conditions are such, because you're building a new house?
That's right.
I don't know if it's impacted by your side yards, but could you not have designed it with the entrance at the side or at the rear?
It'll be more convenient for us to have it at the front.
Right.
And if we were to have the basement walkout at the back as well, it would reduce the rear landscaped area.
Your front yard landscaping is actually will be less than the current conditions. Is that correct? The site statistics that are on the plans? So your front landscaping is going to be less than is currently there. You don't currently meet the bylaw, but you're in excess of what you're, what would...
It would be a bit less, yes.
So what is it you wanted to show us? Do you want to show us landscaping on the street, which is your argument?
Well-
Or do you want to show us that there are
We
front
want to show
yard,
you pictures of
front yard? Because I personally don't need to see those. The fact that they exist on other streets, to me, is irrelevant. What is relevant is if you've got information about the character of the landscape space on this street. And to my colleague's point, the existing front yard landscaping.
I don't have that data, but I drove by and I've noticed that a lot of the front yards are paved. They're not landscaped. As opposed to us here, we have part of the front that it is going to be landscaped, not
There's two
paved.
parts. There's the landscaping and the fact that it doesn't look having a second door at the front. As they say, the proposal to build a new dwelling should be redesigned to accommodate exterior access to the basement level that is in keeping with the existing physical character of the neighborhood. So there's the issue about the hard landscaping and the runoff and the water management and all of that. And there's also the issue of the look of the street. And as my colleague has mentioned, there are no others on this street. There may be on other streets But when you create a precedent, and the city's trying to move away from that. So given that, you know, it's not like an existing house where you're doing an addition and putting in the basement, you're actually building a brand-new house. So as you're building a new, brand-new house, why can you not design something that has an entrance on the side? I realize a rear entrance is difficult in the winter, they have to get around, but what about, you know, a side entrance? It would seem to be something that you could have designed.
Well, as you can see, we're quite close to the side property lines.
But in addition, in granting a variance, there are 4 tests that we have to meet. It has to maintain the intent and purpose of the bylaw, the intent and purpose of the official plan. It has to be deemed to be minor in nature, and it has to be deemed to be appropriate development. The Planning Department's report indicates that this proposal does not, in fact, maintain the intent and purpose of the official plan or the bylaw, which is a pretty serious statement. I'm inclined to agree with it. I don't hear that you have evidence that would counteract that position.
Especially because it's a brand-new build, and you're saying there's no sideway, you can design it such that you have enough of a side yard to accommodate a side entrance. You know, if you had an existing house, then there would be some sympathy, and in some cases, we have streets where there are many such situations. This street, as you own it, you admit there are none on the street. So, any further questions? We ready for a motion?
I'm ready, Mr. Chairman. I'd like to move approval of the application, but revised to not include variance number 5 relative to the front yard landscaping. And also, I'd like the approval to be conditional upon forestry conditions 2 and 3, and I believe my motion already covers the planning department's condition.
Thank you.
I'd second that.
Okay, so you have approval on that basis. Thank you.
Thank you.
Thank you. Okay, next application is item number 9, 46 Borden Street. It's an application to convert the basement of the 2-story semi-detached dwelling into a secondary suite with front yard walkouts, and to construct a north side 2-story addition and a front 2nd-story balcony. On this application, we have Urban Forestry requesting their condition number 1, and planning has no comment on this application.
Good morning, Chair and members of the committee. My name is Jim Sod. I'm the agent on behalf of the owner of the property at 46 Borden.
Okay.
It's a pretty straightforward application. If you wish, I can walk you through about 8 examples I have of both porch roof terraces as well as front entry basement stair walkouts.
Okay, this one you have the same condition that we just dealt with in the previous application, but in this case, planning have no concerns because I guess there are other examples on the street.
Correct.
You've also offered, I guess, to show us the encroachment of the front balcony into the front yard setback. Committee members, would you like to see that? Would you like a presentation, or you just have some questions?
I don't need a presentation, just have a question.
Okay.
Yes.
So is the walkout taking the same footprint as the current porch?
That is correct.
And could you advise, you have information on other front yard walkouts on this street?
Yes, there's
How many,
several.
roughly?
I stopped after I got to about, for the front walks, I have about half a dozen here, and for the balconies, I have about 8.
That's good enough. Thank you. I'd like to as well thank you for the perspective drawing, which really helped to clarify the issues on the application.
My pleasure. Thank you.
Okay, we ready for a motion?
Sure. I'm prepared to move a motion. Through you, Mr. Chair, move a motion to approve the application subject to forestry condition number 1, as I believe it meets the tests under the Planning Act.
Second the motion.
Okay, you have unanimous approval. Thank you.
Thank you, members of the committee. Appreciate it.
Okay, next application is item number 10, 73 LYND Avenue. This is an application to alter existing 2-story semi-detached dwelling with 2 dwelling units by constructing a rooftop deck with an accessory enclosure. And on this application, we have community planning memo recommending 3 conditions of approval and a 9-signature petition in support, no opposition, signed by area residents on LYND, Howard Park, and Dundas Street West. Good morning.
Good morning. Honorable Committee, I'm here. My name is Roman Lisiak. I'm the owner of 73 Lynd Avenue. We're proposing to construct an exterior roof deck with a stair access enclosure from a second-story apartment at 73 Lynd. The dwelling is presently an existing two-story semi-detached duplex with a unit on the ground floor and basement with an access from the rear, and a second unit on the second floor with a separate entrance at the front. We're looking to better the unit by providing an exterior space for the upstairs tenant that presently is using the front lawn as an exterior space.
Have you seen the planning report dated March the 12th?
March the 12th, 14th, I have the committee, what is it, the
It's the staff report from
staff
committee
report.
planning.
Yes, I saw
So they,
from Ms. Wang.
we have one from Linda McDonald.
That I have not seen.
Okay, let's see, just there's recommending we impose 3 conditions of approval. They just want to make sure that the.
Yeah, this is, I have this document from Ms. Wang, yeah.
You're okay with
So
them?
you're okay with those conditions?
The only one that I have is the height restriction. They listed as 9.72. My drawings have always shown a cumulative height of 9.96. So I don't know where that mistake happened, the 9.72. My drawing 03.1 that shows the side elevation shows cumulative heights of 1.07 meters, 3 meters, 3.15 meters, and 2.74 meters.
Variance number 3.
Yes.
On the notice speaks to side exterior main wall height of 9.72.
That's correct.
So that's
We can't go beyond that.
where they,
That's where they picked it up. And if you're saying you need 9.96, you have a problem because it's on the notice as 9.72. They just want to ensure that it's only with respect to the
stair
matter of the
enclosure,
stair
that's correct.
enclosure.
Yeah, that's fine.
But we can't go any higher because you'd have to have re-notification. As silly as it seems for only a, 0.2 of a meter.
It's 8 inches though, right? Which is like a roof structure,
Right. Well,
which will pinch me out for the roof structure. The only thing is the drawings have always shown it as 9.96. I haven't amended any drawings that have been existing.
the notice issued?
No, I didn't.
because you see you have 3 variances.
That's right.
One of your variances, it's the altered 2-story semi would have exterior side mall height of 9.72. So we can't
Right.
give you more than that. So maybe we should, you can.
There's no way to amend that.
If you didn't notice it, you should have noticed it when the application.
Right.
You advised, alerted staff to that effect. So I don't know how that happened.
I have another question that I guess is related to that. On the same elevation drawing that you mentioned, A03.1, it appears to be a roof that goes over the entire deck. Is that correct?
It overhangs the 2 sides. So
Yes.
one's an overhang to shelter the entrance from the stair entrance.
Okay.
And the other one is just a sun shelter that extends on the other side of the stair enclosure. The roof is only part of the stair enclosure itself and does not extend any further past the stair enclosure that comes up from the second story.
I'm trying to determine if we have to make note of that in any decision, because I think the planning report is written on the basis that there's just a stair enclosure. In fact, there is an overhang on either side. I would argue that that overhang is part of the stair enclosure, but going forward, you might want to clarify that with the building department, planning department, to make sure that if this is approved, that condition applies to that roof as well. Otherwise, you have a problem with the roof.
The 9.72. Yeah, no, I would assume that height restriction applies to that entire structure
But
itself.
you might want to clarify that.
Sure.
Okay.
It's 0.24 of a meter off, so you can perhaps, as a matter of interpretation, try to massage that because we can't grant you the 9.96.
Gotcha.
Because you didn't ask for it.
Right.
Public notice, it didn't, well, you may have. it didn't-
I have asked for it, but it wasn't caught.
Yeah.
I understand. I'm still seeking to that approval for the 9.72 then.
Are there other rooftop decks in the neighborhood?
There are other ones that have a 3rd story structure, so that was one of my variances that I'm looking for as well, is the access from a second story rather than an entire third floor on this house, which I'm not going for. It's just a stair enclosure, so. I've also, according to Ms. Wang's report, that staff report, also providing privacy for the side neighbors. I'm in agreement with the 1.5 meters at the north and south fencing privacy, as well as setting back the east guard 1.5 meters. She's mentioned from the rear wall, but I've clarified it with her twice now that it's from the roof edge, because that is where your visual line is, not the exterior wall below, because we're trying to provide privacy for the neighbors itself. So I've drawn it as 1.5 meters from the roof edge, which is in the elevation 3.1 as well.
Your main wall.
So it's a technicality that I've tried to clarify with Ms. Wang, but I have not gotten any responses from her.
If this was approved,
Yes.
as written, does that create a hardship for you? I can understand what you're saying, but
I've explained to Ms. Wang that it pinches me out with the walkout point.
So
where
yours
the
is-
stair happens.
okay, I understand. So you're recommending that it be, or you've proposed to her all along that it be 1.5 setback from the roof edge?
Correct.
Instead of the rear main wall.
I think that's reasonable. Thank you.
Okay. Any further questions, or are we ready for a motion?
Ready?
Yep.
Mr. Chairman, I'd like to move approval of the application subject to the Planning Department's three conditions, with condition 2 reworded to read that the rooftop deck be constructed substantially in accordance with the rooftop plan, providing a 1.5 meter setback from the roof edge, as per the rooftop plan received by Committee of Adjustment on January 17, 2019.
Thank you, Mr.
I'll
McCall.
second that.
Okay, you have unanimous approval.
Thank you very much.
Conditions. Thank you. Next application before us is item number 11, 33 Whitehall Road. It's an application to legalize and maintain 3 dwelling units located in a detached 2-story house. There is one variance. The size of the house required to have a secondary suite as a minimum interior floor space of 460 meters squared, and in this case, this house has interior floor area of 368.64 meters squared. It's something I don't often see as and that's your only variance. And we have no concerns from Heritage Preservation Services, and we have correspondence and concern from 32 Douglas Drive. Good morning.
Hi, my name is Joe Dome, 1101 Steeles Avenue West, agent for the applicant. We have read the concerns from the neighbor, and as far as their statement that it's not within character of the street, we find that odd because, I mean, the property has been a triplex for at least 20 years, and there are at least 15 multi-unit dwellings on the street. For example, 89 and 81 Whitehall are legal triplexes. And there's also a legal multi-unit number 47, which is the same size as 33, and as well as 53 Whitehall. And the Ratepayers Association doesn't have any issues with this application. And we feel that legalizing this existing triplex fits very well within the existing character of the street and is positive regarding increasing need for density.
Okay, thank you, Mr. Doe. Members, any questions for Mr. Doe?
I have one question. Can you tell me, on your site plan, there's a garage in the back. How many parking spaces are available on the site?
I'm not entirely sure, but as far as the fact that there's no parking spot variance, so it doesn't seem to be an issue.
As I read it, the reason I'm asking the question is I read it, there's a right-of-way along the east side.
Mm-hmm.
The right-of-way leads to an existing garage. In front of the existing garage, there's a parking pad, and then there's the driveway itself. It says it's landscaping existing, but it's also called a right-of-way, so I'm not sure. I'm not sure how you get to the parking pad. I'm not sure how you get to the garage. But assuming one can get to them, it would appear you've got 3 parking spaces.
Yeah, I'm not quite sure how the existing landscaping, at least the way it's listed, it's possible that there's an error there. But it seems to be that within the existing situation over the last 20 years, that parking hasn't seemed to be an issue. Even with, I'm sure if there was an issue with parking, the Ratepayers Association would certainly have an issue, and there would be multiple concerns there.
Yeah, there is no variance showing for parking deficiency.
That's right.
I'm just responding to the objector who said that there's a problem with parking on the street, and there's an absence of parking in the area. And then I looked at what you're proposing, and as far as I'm interpreting it, you've got at least 3 parking spaces. I just wanted to clarify, you don't know.
I'm not sure what exactly what the existing parking situation is.
Okay. Any further questions, or are we ready for a motion?
Here to move a motion.
Okay.
Through you, Mr. Chair, move to approve the application, as I believe it meets the tests under the Planning Act, and there's not going to be any impact on in the neighborhood.
Thank you, Ms. Hayes.
I second the motion on my understanding of how the parking works. It would have been better if we'd had a clarification, but I second the motion.
Okay, you have unanimous approval. Thank you.
Thank you very much.
Okay, next application is item number 12, 57.5 Melville Avenue. This is an application to alter the existing semi-detached dwelling by constructing a rear 1-story addition and a rear detached garage. We have 3 variances, and we have the materials filed with the application, 6 photographs of the property, a party wall agreement between the neighbors, and 11 form letters of support. So it looks like you've done your homework. Can we get your name and address, please?
Good morning. My name is Sunny Gervin. I am the applicant, 115 River Road.
Okay, thank you. Committee members, you want a presentation on this, or?
I just have a question. Is the garage a 2-story garage, or is it just, it's very high?
Just a 1-story, all within the limits of the approved garage height, under 4 meters to the top of the sloped roof.
So your proposal is not to add a second level, it's just to use it as a garage, okay?
That's correct.
Okay.
Are you building on an existing footprint?
It is very close to the existing footprint. The existing footprint actually encroaches into the public right-of-way to the east very minorly, but we would pull it back from that edge so that we would have some space to also have a very small overhang
Yeah,
there.
it's just, the question was mainly with respect to the variance number 2 of why you couldn't comply with the 1 meter from the rear.
And the rear, it is also in line with the existing garage, which is also in line with many of the existing garages that go down that road.
Existing condition.
It is an existing condition for all intents.
Thank you.
Any further questions from Mr. Urban, or are we ready for a motion?
I'd like to move approval of the application without condition. It appears to be reasonable development. It seems to meet the 4 tests for variance. And I noticed that there are no objections, and it's a semi-detached, so obviously you've done your homework.
I'll second that.
Okay, you have unanimous approval.
Thank you so much. Have a good day.
Okay, next application is item number 13, 19 Claude Avenue. This is an application to alter the 2-story semi-detached dwelling permitted in Committee of Adjustment decision in 2018 by constructing a front parking pad. And on this application, we have photographs of the existing driveway, the previous decision from 2018 affecting the property, a letter of explanation from Mr. Isaac, the applicant owner, and we have from the city department's right-of-way management having conditions of approval, whether it's approved or not. And we have 3 form letters of support signed by 14, 16, 21. So we have the neighbor, Jason, on one side. It doesn't look like we have the neighbor at 19. Again, this was already approved for other reasons. in 2018. Good morning, sir.
Good morning. My name's Ron Isaac. I am the applicant.
Yep. Okay, we have your letter, we have your neighbors. Let's see, have you seen the right-of-way management memo?
I have.
And you're okay with that?
Yes.
In the event of approval?
Can you clarify what has changed since the last decision? You removed almost all the variances.
Of course.
But what specifically did you change?
So the approval which was granted, we still intend to proceed with all of that work.
Okay.
So at the time of the previous decision, the wording in the recommendation by right-of-way management included any parking space within the driveway would encroach onto Municipal Boulevard. So the recommendation was to remove the existing curb cut and driveway. So that statement that any driveway would encroach onto the Municipal Boulevard is not accurate. The matter was discussed with right-of-way management, and we are able to locate a parking space within private property in the front yard.
Okay, so on the previous decision, one of the conditions was that the obsolete driveway, including the portion of the existing city boulevard, shall be restored to soft landscaping, et cetera, et cetera. So now that's what you're coming back to, actually have the front yard parking. So you're still obviously have your other variances that were granted in 2018. And now you're just coming back to these two additional variances with respect to the front parking pad.
Correct.
Okay. Any further questions for Mr. Isaac, or are we ready for a motion?
No further questions for me.
Mr. Chair, I would move to approve the application subject to the condition in the transportation or right-of-way management memo of November the 26th, as I believe the application is appropriate and meets the tests.
Okay. Okay, you have unanimous approval. Thank you.
Thank you very much. Good morning.
Okay, the next application we're going to deal with is item number 14. Oh, that's right. No, that was the one was a small H. The applicant wasn't here when I divided the agenda. Is someone here from the applicant agent on 442 Margueretta Street? Okay, you weren't. So you were a little bit stuck in traffic, I guess, this morning. Is there any neighbors here on 442 Margueretta Street? Okay, so then we can proceed. Okay, this is an application to alter the existing two-story semi-detached dwelling by converting the basement area under the front porch to habitable space and to relocate the front entrance stairs. We have on this application correspondence and support from 442 next door, and that's all we have other than materials filed.
Yes.
Good morning, sir.
Good morning. My name is Michael Taylor. I'm the agent for Mr. Ming. We have a current permit on file to make that front porch, and basically we're just wanted to locate the stairs. Unfortunately, it's a very tight land area that we just need to put the stairs in the front, and we're going to be close to the front property line, and we'd like to convert the area under the newly built porch into a bathroom.
Okay, so and then there's some, the agenda was revised about the measurement of the front stairs from the front lot line. It's being measured to the front wall of the converted basement level containing the habitable space.
I wasn't aware of that. I don't believe we've changed anything. I think it's about 5 inches from the front lot line.
I think we just added as a descriptor.
Oh, okay, because we haven't changed anything. It's a common condition on the street. You can go up and down the street. A lot of houses have the front stairs. It's just having to comply with the bylaw.
For sure. Thanks. Okay, thank you, Mr. Taylor. Any further questions, or are we ready for motion?
Mr. Chairman, I'd like to move approval of the application. I think it clearly meets the four tests and is minor in nature.
I second.
Okay, unanimous approval. Thank you.
Thank you very much.
Item number 15 is 196 Montclair Avenue. This is an application to relocate the existing driveway from Bathurst Street to Montclair Avenue. Avenue was written twice, it's a little typo, and to establish a new front yard parking space. And we have on this application Urban Forestry requesting their conditions 1 and 2. We have a covering letter from David Eichler, the applicant. We have right-of-way management memo. We have with a condition of approval. And we have correspondence in opposition from the neighbor next door at 194 Montclair. Good morning, sir.
Morning.
Get your name, please.
It's David Eichler.
Okay. The applicant and owner. Okay. Committee members, would you like a presentation from? No. Okay. Any questions for Mr. Eichler?
You're aware of the condition being recommended by Transportation Services with respect to the restoring of the Bathurst Street?
I didn't get any letter, but on my drawings I wrote.
14th, Transportation Services does not object to the front yard parking space on the condition which is located entirely on private property. The driveway within the boulevard that is servicing the garage on Bathurst Street must be restored to soft landscaping and the curb cut restored as to full-faced curb. Both these conditions.
That's reasonable, yes.
Okay. I have no other questions.
Okay, this is a single-family home?
Yes.
Yeah.
Okay, and there's some mention from the neighbor about they already have parking for 4 cars or something, or what's the situation there?
It's a very small 2-car garage.
Right.
And I have possibility of 2 cars in front of it.
I guess your problem is backing out of your driveway onto Bathurst.
Yes, the house is about 100 years old. Its traffic was a bit later back then.
I would imagine. So it says it must be almost impossible to back.
It is. And there's also a bus stop, like right just south of me. So it's actually, there's been some close calls.
But if I were, I would have backed in and then driven out.
Well, it's not so easy to back in during rush hour.
Yeah. Someone's going to come up and...
Yes.
Okay, challenging situation. Any further questions for Mr. Eichler, or ready for a motion?
Mr. Chairman, I'd like to move approval of the application subject to the right-of-way management condition, which you've now reviewed.
Yes.
And forestry conditions 1 and 2.
I'll second that.
Okay, unanimous approval.
Right, thank you.
Okay, item number 16 is 156 Chiltern Hill Road. This is an application to alter the existing 2-story detached dwelling by constructing a 2-story rear and side addition, a front and rear canopy, a rear ground floor deck, and by redesigning the front and rear landscaping. And on this application, first we have correspondence from the agent together with an urban forestry permit. We have right-of-way management requesting conditions of approval, and we have urban forestry requesting their condition number 2. We also have 4 form letters in support from both adjacent neighbors and 2 others. 2 on either side, looks like, 154, 158, 160, and 164. Good morning.
Good morning. My name is Brenda Eisen. I'm the architect for 156 Chiltern Hill Road.
Okay. Let's see if committee members want a presentation from you, or if they have any questions.
Have you seen the report from right-of-way management with the drawing attached?
Yes, I'm aware of the report. Both the first 2 variances are the landscaping variances. These are an existing condition from when the homeowners bought the home 8 years ago. And cosmetic work to the front of the house and landscaping is budget dependent. So if we're willing to consider their opinion, but if we're not doing any work to the landscaping, then it's not going to be in the budget to change the location of the parking pad or the curb cut.
So you're saying that the decision is flexible right now, or it is?
We will take it into consideration, but I would propose to keep the existing landscaping as it is.
It's not very, it looks like you're going from 0.75 to 0.72, which is you're deficient like less than half a meter. It's
correct.
And equally, the minimum, the front yard landscape as opposed to landscape open space is also rather minimal of 4 meters.
Mm-hmm.
Any further questions, Ms. Eisen, or are we ready for a motion?
I don't have any further questions. Through you, Mr. Chair, prepare to move a motion to approve the application, as I believe it is indeed minor. And I accept the position of the applicant with respect to the transportation condition.
So what about the urban forestry?
With the urban forestry condition, though.
Condition number 2?
Number 2,
Yep.
yeah.
That's correct, I read into the record, but...
So we don't need to add the condition?
Is it with respect to those trees, though, or that particular tree, do we know?
Well, if they have it, and the
Silver
conditions
maple.
there, it's not going to create a problem.
No,
Yeah,
but it's
silver
on their
maple.
list, so I just-
This is with respect to the silver maple in the rear yard. It's for permit for
Yeah.
tree injury or destruction, so we know that that's specifically the one that they were talking about in their report. I guess it doesn't hurt to keep it in.
I think we should keep it in, and then if it's not,
Yeah.
it's not applicable or it's already been covered, then I think we're fine. So I would say subject to forestry condition number 2. That would be my motion.
Second the motion.
Okay, you have unanimous approval, thank you.
Thank you very much.
No.
No. Okay, 17 is being held, so we'll move over to item number 18, 36 Elgin Avenue. This is an application to alter a 3-story semi-detached dwelling by constructing a rear 3-story addition with a basement and the expansion of the existing roof deck. We have one variance, which is the building depth of from 17 meters to 21.95 meters. And we have before us on this application correspondence and support from 3 letters from 34 Elgin, 9 Thornbank, and 41 Boswell. And we have correspondence from HPS advising that they've already given approval, and we have a previous decision of committee affecting a property from 2014. Good morning.
Good morning. My name's Cindy Renderly, and I'm the architect representing the homeowner at 36 Elgin Avenue.
Okay.
And you've stated our purpose of our application to construct a new 3-story rear addition to our client's existing 3-story semi-detached dwelling.
Okay.
Would you like me to continue with the presentation?
Sure, you might as well.
Okay.
Kristen is up here, and thank you for bringing it close so we can actually see it.
Okay, so as long as you can hear me and you can see Andrea, okay. Well, as you have stated, we have 3 signed letters received from 3 homeowners supporting the application, and each owning properties that adjoin ours at 36 Elgin Avenue. Specifically, they're located at 34 Elgin. That is the dwelling located to the immediate east of our property. 38 Elgin is the semi-detached dwelling adjoining our property and sharing the west side of the common wall.
Do we have a letter from them? 38?
Yes, we do. We have a letter from 34 that I just stated to the immediate east, 38 that shares our common wall, and 41 Boswell is a neighboring property located immediately behind ours, abutting the rear lot line.
Okay, Ms. Renderly, what screwed me up is that the neighbor is Thornbank, they own 38, so.
No worries.
On our agenda, it says they're at 9 Thornbank, but that's just where they live, but they're the owner of 38.
No worries.
Okay.
Okay, these neighbors obviously will be impacted the most by our application, and they support the proposal. In addition, our clients have reviewed the proposed C of A application with the following homeowners, and they have advised my client that they will not object to our application. And these are neighbors all along the street of Elgin Avenue at 28, 32, 35, and 40, as well as 39 Boswell Avenue. And we're unaware at this time of any neighbors that have any questions or concerns. And again, it's important to note that our property at 36 Elgin and the adjoining property immediately to the west at 38 do share a common wall, as referenced on the site plan in green.
Right.
And both property owners have designated the shared common wall as a party wall, and they have a legal and binding party wall agreement. We do have a copy of that if you need to see it.
That's not necessary.
And also the adjacent semi-detached dwelling located at 38 recently had a successful public hearing in October 2018, and the minor variance application was approved. And the purpose of the application was similar in nature to ours, to construct a new 3-story rear addition. The new approved overall building depth for 38 Elgin is rendered in yellow on the site plan.
Okay.
Our proposal seeks
Okay.
Our proposal seeks possible relief from the zoning bylaw requirements with respect to one variance only, and that is the building depth.
Yeah, which is consistent with next door, so.
Correct. I mean, the short version of the story is that the building footprints align both the ground and second floors, which is highlighted with the black dashed line on the site plan. So the extent of our proposed addition at the rear elevation echoes the approved addition at the rear elevation. Really, they're identical in their building footprint.
Okay, thank you. Any further questions? Thank you for that presentation.
We have a proposed and an existing north elevation, which is the back. We have only the existing south elevation. Do I assume from that that nothing has changed?
Nothing has changed? No.
So nothing, the addition at the back, it doesn't in any way, it isn't visible from the street because
Correct.
it's completely behind.
It's aligned, the continuation of the side walls just extend to the rear yard.
Okay. There's nothing visible. Okay, thanks.
Thanks. Okay, any further questions?
Thank you for the
Ms. Rendell?
drawings, that was helpful.
Thank you.
Or are we ready for a motion?
Through you, Mr. Chair, I'd like to move a motion to approve the application, as I do believe indeed it is minor and sort of mirrors the neighbor next door and is certainly not out of character with the neighborhood.
Second the motion.
You have unanimous approval. Thank you.
Appreciate it greatly, as does our client.
Okay.
Thank you.
I'm advised by my colleague that today's International Happiness Day. Hopefully, we can make everyone happier today.
Thank you again.
Okay, so the last uncontested item, then we'll go back and do the held items, is item number 20, 126A Glen Road. This is an application to alter the existing two-story converted detached dwelling by enlarging the front second-story deck, and there is only one variance, that the front second-story deck encroaches into the front yard setback and be located 0 meters from the east front lot line. And we have on this application we have right-of-way management telling us they have no comment, and Heritage Preservation saying they have no concern in scheduling. So we really have nothing, no comments from city staff or area neighbors. Good morning.
Good morning, Honorable Committee. I'm Jeff Lung from MHT, Markham High Tech Architects, representing the client.
Okay, rather straightforward. Let's see if committee members would like a presentation, or if they have any questions.
I have a question, Mr. Chairman. The impact of this variance would be on the street. We don't have any elevation drawings to show us what it currently looks like and how that might change with the variances. Do you have those with you?
I have a picture of the image there that we can show you.
Please.
And can you show a picture that we put on the screen there?
It's on the screen.
The road itself is very angular in nature, as we can see, and so if we had followed we're trying to keep with.
That's existing condition. What changes?
It's the second-story porch that we've rebuilt, and basically it's the same dimensions as the first floor, so we basically kept the footprint, the size of it. So right now it seems to be protruding beyond the property line. So if we would have kept within the property line, it would have been, the facade would be very odd looking, and it wouldn't be keeping with the neighborhood and also the heritage architecture of the house.
So effectively, the impact from the street is not going to change from the photograph?
No.
So this is built, so it's already
It's already built, yes.
Okay, so it's to legalize it, okay. Thank you.
Do you have any questions?
No.
Mr. Chairman, I'd like to move approval of the application. It clearly meets the 4 tests and is very minor in nature.
I second that.
Okay, you have unanimous approval. Thank you.
Thank you.
Okay, so now we're going to go back to the held items. I don't know if people are still out in the hallway having meetings, but just to recap, we're going to do item 1 first, 25 Lamport, item 3, 66 Harper, then item 4, 447 Winnett, then number 6, 525 Ossington.
Through you, Mr. Chair, I believe the item on Ossington, there's no opposition anymore, number 6.
Okay.
Perhaps you can do that first.
Okay, we can do that. And then just to continue on, then we'll do item 17, Hillsdale Avenue East, and number 19, GLENAYR. So we'll call item number 6 first then. Item number 6 is 525 Ossington. It's an application to convert the existing 2-story semi-detached dwelling into 3 dwelling units and to construct a front second-story addition, a rear parking pad, and rear stairs with a second-story platform. And we have before us on this application nothing whatsoever, just the materials filed with the application. No comment from neighbors, no comments from city departments. Thank you. 3 copies.
Thank you.
I wonder, in your presentation, could you address 2 items for me? One is the stairway at the back is rather extensive and appears to be invasive to the neighbors. I'd like to know if that was what the objection was and how you've resolved that. And secondly, is the basement walkout into the front yard, is that an existing condition or is that something you're proposing? Okay, so as long as you address those things, I'd be very happy.
Okay. Oh, yeah. Oh, so I'm Ying Yi Li, the owner of the property. So, I'm here to apply a minor variance permission for my property and of converting the single-family residential house to a house containing 3 units. So, according to the zoning bylaw notice, so there's some few items as not satisfied. As I know, I don't have any like a front addition for my property, so the item 6 and 4 is not applied for this case. And then the item 2 indicate the floor space of my property is 0.79 times of the area of the lot. Is over the permit maximum floor space index 0.6 times the area of the lot. So,
you've given us some materials, you've given us a decision from 2006 that it looks like I was one of the signatories to, where the GFA was 1.07. I'd note that under your zoning review, under the old bylaw, you would be 1.17, and under the new bylaw, I assume maybe the basement's not counted or something, it's 0.79 times the area of the lot.
Okay.
I would compare what you've given us to the 1.17, not to the 0.79. Just wanted to clarify that, because this was done before, under the old bylaw in 2006.
Okay. So, so back to that, the stair, like on the back, the neighbor just say that's okay for them.
Okay. So even though we don't have any letters, you're saying you've spoken to the neighbors and they're okay? You spoke to the neighbor behind?
Yeah.
Is there some reason you didn't do them as a switchback stair versus the length extending back into the yard?
No, it's just like for the escape for the second floor and in the middle of the property and just all the way to the middle of the back, yeah.
But the question is, there's another way of doing it. Instead of going like that, you can go like this, and then there isn't so much. The concern I have with the stairway is that there's a privacy concern. What if there was a really big party? The party could spread out in the stairway. You could have 50 people on the stairway, creating a privacy concern for people on either side of you.
Okay.
The switchback stair as an alternative would provide less intrusion to your neighbors.
Yeah, I can do that. When I get the stand in the middle, and I can turn left, and can make the requirement for that.
What were the people objecting to that were here? Resolved whatever that problem was.
He just concerned about the front addition because I don't have the front addition for that, so that's the concern about. Because in the beginning for the.
So, sorry, my name is Dawn. I'm the owner of the 525 Ossington Avenue. As the gentleman said, my neighbors 523, the Ossington, they are concerning about whether we have to build, because the commitment adjuster said that it's over the capacity. So they are concerning whether we will build the 3rd floor. So they come here and to see whether we have to build a 3rd floor or extend our existing property to more the footprint. So they're here to see the floor plan. But as we explained to them, we keep all the existing building structure. We don't add anything except the stair at the backyard for the legal fire escape.
And was that the owner that you're assuming? Is it the owner,
It's
house is attached to yours?
Yes, that's the owner attached to us. It's 523 the OSSINGTON Avenue, and we are shared a common ward. And as you said, the stair at the backyard, it's not attached any of the boundary of the yard, and it also has a setback. It's just a small one as the standard of the fire escape stairs. So it's basically not considered as a balcony. It's just for the safety legalization escape.
So is it required by the building code?
No, it's not. It's by building code, but it has the problem because we extend.
Take it off or not?
Sorry.
Took it off, would you be in compliance?
No, we cannot because it's for the building code. We have.
That was my question. It is a building code requirement.
Yeah, it's a building code requirement, and we have to make that for the safety for.
Protection.
Yeah, fire protection. And it will just go along our backyard. It will not be extended and will not be used as a balcony. It's just the size for the landing.
So is the depth variance occasioned because of the rear stairs, that the concern is that it's not switchback? The depth, like how does that issue refer to the variance as extended to the old one?
Yeah, because we extend
It's 26.66, the depth. And this one, the depth is 19.48 under the new bylaw. It's a different measurement. But, and both of you.
I think it's related to.
Both of you
all the
commented.
variances, because the variances allow for a larger building, and the larger building means that this top floor needs to have access.
Yes.
I'm very concerned. If I lived next door to that stairway, I would be objecting to that because I think it's very intrusive to the neighbor.
Under the old bylaw, it counts to the
Right,
the depth goes to the, structures attached to the rear wall of the building.
Can we impose that as a condition, or do we have to, that there's?
That's why it's 26.66, because it includes the stair.
I just think I have some concerns about the stairs.
Yeah, I do too.
So the depth of 19.48, is that the existing depth of the structure?
Yeah.
Yes. Okay, so that's an existing condition.
So that doesn't, it's not longer because of the stairs.
Yeah. And the stairs for the exception for.
We deal with that as a condition, the grant approval.
Second floor.
The understanding that they.
So that would be a suggestion that
rear
there
fire
isn't a
escape
variance
or-
for the stairs under the new bylaw.
And you're saying it's not affected by the depth?
Because all the other variances allow the building to be bigger.
Yeah. But it can go to impact.
So if you look at the switchback, how do you? So can that be imposed as a condition that they revise the rear stairs with a be constructed in a different manner to provide it's a term of art to say switchback.
The concern I have, Mr. Chairman, is this could very quickly be deemed as a precedent, and we could see these all over the place where we have these in other locations. If the adjacent owner doesn't object, I'm surprised, but if this became a precedent, I don't want to have my name attached to this as a precedent, which I think is bad. There's got to be a better solution.
Interesting that planning didn't comment on
I
this.
don't think they caught it.
Yeah.
The stairs are from an impact perspective.
They're huge, yeah.
And on adjacent properties and.
And they're
precedent.
narrow properties as well, so.
Yeah. It's very narrow. I mean, it's just like looking at a structure.
It is, well, it is a structure.
Well, it's well above the.
And the reality
How much
is
of it is
can be.
above the fence line?
Well, it can be populated as well as a staircase, it can be populated.
Even with the switchback, I guess it could be populated too, but it's.
Well, considering the
this is
fact
more-
that there's a deck here that already sticks out and it's on a narrow property.
Right. Okay. So if you were inclined to approve it otherwise, other than this issue, how do we deal with that? We add as a condition that the rear stairs be revised so that it's not a straight staircase and is done as a switchback. I don't know if that's a architectural term or.
It is, yeah, it's an acceptable term, but I'm not sure.
So is there some way you can save this application by imposing that to condition as opposed to refusing the application?
I'm cautious about a condition that pre-designs the stairway.
Plans for it, right?
No, I'm more inclined, Mr. Chairman, I'm going to move approval or denial of this application. And my reason is based on the intrusive nature of the stairway. I would encourage the applicant to look at alternative ways of providing access to the top floor. But in its current condition, I'm unable to approve this solution because I think it is potentially precedent-setting, and I think it's very intrusive to neighboring properties. On that basis, Mr. Chairman, I'm going to move that the application be refused.
So, okay, I'm sorry, we're in committee. We can't have any more comment. Okay, I would agree. So the application has been unanimously refused. Okay, so your application has been refused because of the stairwell. Okay, so if you have any questions, please call staff tomorrow as to what your options are.
But just to clarify, the reason I put those reasons in is it's the stair that we're all concerned with. You need to look at some old.
Yeah, it's not the full stair, like, because they have.
No, we can't have any more debate.
But going forward, I would encourage you to look at alternate ways of providing access to the top floor, because that stair is very intrusive.
Okay, thank you. We have to move on to the next application, regrettably. Okay. Okay, so we're now going to go back and do the following. We have number 125 Lamport, then we'll do number 3, 66 Harper, then we'll do number 5, 447 WINNETT, and after that, number 17 Hillsdale, number 19 GLENAYR. So we have those remaining applications. So the first one was 25 Lamport that we'll call, and I'm going to recuse myself. As I stated, I have a conflict, and hand the gavel over to Ms. Hayes.
Good morning.
Good morning. Just before we get started, I want to let you know what the committee has before it. Copy of plan of survey, site plan, floor plans, and elevations. Covering letter from Stuart Watson, the agent. 6 photographs of existing garages in the neighborhood. Correspondence from Libby Burnham at 21 Lamport. Correspondence from the assistant planner, community planning. Previous decisions of the Committee of Adjustment affecting the subject property, correspondence from the acting project manager, archaeology, Heritage Preservation Services, city planning, staff report from the program manager, Heritage Preservation Services, 7 form letters in support signed by the owners of occupants of 469 and 26 Lamport Avenue, 2 May Square, 2 May Street, and 176 Crescent Road, and a letter of a concern or interest from the South Rosedale Residents Association. Thank you. Could we have your name, please?
Stuart Watson, drawing room architect.
Okay.
So I'm not sure what's on the screen there. I added at the very last minute. Is that in your file?
No, it isn't.
No.
Okay. Basically, all the green are letters of support.
And you're the red one. You're the red one, right?
The only 2 houses.
You're the red one, right?
Pardon me?
You're the one that's outlined in red?
We are outlined in blue. We are clouded in blue, and the neighbor who has concerns is outlined in red. And the 2 white houses between Ms. Burnham and the first greenhouse are elderly, unwell, and we were unable to reach them, so they're not against it. Everyone on the street who we could talk to supports this.
Thank you.
With the one exception.
Could I ask a clarification?
Yes.
If the appellants need you to make a full presentation to understand it, I'm happy with that, but I had a question about parking. As I read it, you're proposing to put a garage close to the west property line. there's a driveway leading to that garage, there's a driveway beside that garage, and there's a driveway, that driveway extends out to the street. And there's a garage at the back of the property. If the garage at the back of the property were used, and I don't see how it could be because I believe there's a tree blocking access, and the only way you could go is along the side of the house. I don't know if it's your intention. As I read it, you've got 5 parking spaces. Is that correct?
All the parking that you see there is all existing and not relevant in terms of the variances. We meet our landscape open space requirements. It's correct that the existing garage in the back is not accessible. It's too narrow to get a car down the side, so that hasn't really been used. Everything else is just existing and not relevant to the variances being sought today.
Except for the one garage adjacent to the...
Right, but parking is not a variance. There is no parking variances. The variances are related to setbacks.
Yeah, okay, but it's related to that garage.
Okay.
Okay, thank you.
Okay, with respect to the setback that you're requesting, can you point to, why can't you meet the bylaw requirements? And can you point to other properties where similar examples exist to what you're requesting?
So,
with some photographs in the material provided, but if you could.
So in the last, just to answer that question, in the last decade or plus that I've been working with Heritage, having the garage not attached to the house has generally been the preferred move because the house is a historical house. So we also did not want to engage the garage with the house. So we looked at a variety of locations. If we were to avoid the setback variances, we would have to have the back of the garage touch the house, which would mean that we would have this sort of dead alley that goes to nowhere between the house and the garage. So that's not great from a planning or from a heritage perspective. It's a dark, scary, dirty, messy place. So having the garage located where it is, which allows us to walk back between the garage and the house, means that you don't have that dead-end alley there. It means you have nice separation to the house, and it means that you could also park a car between the garage and the house, thereby not having to have cars in the front of the house. So the whole front is landscaped, beautiful space, and the parking is more discreet this way.
Okay. And with respect
and Heritage and planning both support this approach.
And with respect to the height?
The height variance is a technical variance. If we had the garage right on the property line, we would not have a variance. So we moved the garage 6 inches away from the property line to allow for trellises or vines to screen the wall that faces Ms. Burnham. So we could have the garage right on the property line and there would be no variance. I can read out the zoning bylaw. I have it with me if you prefer.
Your variance for setback.
Okay, thank you.
So, if I can read from the bylaw.
That's fine for the moment.
Yeah.
Could we hear from whoever would like to speak to this application, and then we'll hear back from you. Thank you.
Do you need any more of a presentation from the applicant, or is that satisfactory for you? That's okay.
We have your name and address, please.
My name is Andy Margaritas, 425 Adelaide Street West. I am legal counsel to Miss Libby Burnham, the owner of 21 Lamport Avenue, immediately west of the application lands. Miss Burnham has lived at this property for over 40 years. My client is very much opposed to the requested variances. To begin, it's important that I remember and I note that variances are tested based on the Planning Act and whether the requested relief causes undue adverse impact. That said, the test is of planning, and I request that the committee disregard the hyperbole provided by the applicant in its submission related to my client's alleged behavior. Turning to the variances, first for a side yard setback, the requirement is 1.8 meters. They've requested 0.15 meters or 15 centimeters. This is not minor. And without a doubt, this variance, if granted, will cause unacceptable adverse impact on the use and enjoyment of my client's home. For more than 4 decades, my client has enjoyed lovely views of greenery from the primary windows of her living room and dining room. I use the term primary because these are not small windows. They are large windows located, which are used every day and are not located in seldom used rooms. They provide light into major areas of my client's home. For over 4 decades, my client has enjoyed the views that you see on the screen there. And I note specifically the existing hedgerow that has been there for over 40 years. Now the applicant hopes to give her this view. That's of the west side of the garage, which is in stark contrast to what she's enjoyed for over 40 years.
Can you show me where the dining room window is on your client's property? If you look at the applicant's got a site plan, you could show me there where that dining room window is?
Interestingly, the bay window is not shown on their plan. It's located right in around this area, sir.
Okay, you mentioned there were views from the dining room and the living room. Where's the living room?
Correct. They're both along that side lot line.
Further down?
Correct.
Can you put it on the plan too?
Generally in that area. If I'm incorrect, I'm sure Ms. Burnham will correct me. She's suggesting they go all along that side.
Okay, thank you.
As you can see, a bleak and stark contrast. The applicants specifically acknowledge that another option was available to them that would not require relief. The obvious option would have been to move the garage eastward. There is ample room to do this. They simply have chose not to. Creating a variance when none is necessary, in my view, is not desirable for the appropriate development or use of the property. Instead, the applicants desire to create an extension of the second driveway to their proposed second garage. This is not in keeping with the character of the neighborhood. What is also not mentioned is the existing location of the hedgerow that's been there for over 40 years and which straddles both sides of the property line. If this second garage were approved with the variances as requested, the hedgerow would have to go. And the components of that hedgerow on my client's property is something that she is legally unwilling to permit to be removed. Turning now to the second variance for height, the maximum is 2.5 meters, while they're seeking 3.25 meters, an increase of approximately 30%, which in my view is not minor. The applicant has not provided a single planning rationale for this request. I'd like to remind the committee again that this is for a second garage. The applicant has suggested that if the second garage was located on the west side lot line, no height variance would be required. Even if this were true, the committee correctly pointed out that a variance for a side yard setback would still be required in a magnitude larger than what they've requested here today. The additional height, for the reasons I mentioned in terms of the side yard setback, provide undue adverse impact to my client's property. I'd like to point out one more detail I found particularly troubling in a letter the applicants sent my client on November 3rd, which was enclosed with the firm letter we sent a few days ago. As you can see in the second to final paragraph of that letter, the applicant acknowledges that they intend to proceed with this project, in my view, seemingly with or without this committee's approval. But most concerning to me, however, is a suggestion underlined in my copy that when the project does proceed, it may have several aspects to it that will affect your property negatively. This is both an acknowledgement by the applicants that the relief is not minor, and also, in my view, a veiled threat against my elderly client, who also is their neighbor. In summary, the resulted variances, both individually and cumulatively, do not respect or reinforce the physical character of the neighborhood, and as such do not maintain the official plan or the zoning bylaw. They do not take advantage of reasonable alternatives that were available to them. These variances will cause undue adverse impact on the use and enjoyment that my client has made of her property for more than 4 decades. And finally, these variances are simply not minor, both in terms of the quantum of relief sought and the impact to my client. I appreciate this committee's time, and I have no further submissions. Thank you. Unless, of course, you have any questions for me.
I have some questions. So, what is the distance between the property line and your client's home?
Between the property line and my client's home, I believe there was a survey.
Yeah, just.
Yeah, it appears to be 9 feet 7 3/4 inches.
Thank you. I have another question. If there was not a side yard variance requested, so if they were not going to have that variance, how would that alter so they would build the structure but without the side yard variance? How would that alter the impact that you noted to the committee in terms of views?
Oh, quite significantly. First and foremost, it would permit the existing hedgerow, which I mentioned has been there for over 40 years, to be maintained in place. Obviously, the applicants could remove that portion of the hedgerow on their property. However, the portion, notwithstanding they wouldn't have to if they adhered to the 1.8 meter setback. But my client would then obviously be able to maintain the portion of the hedgerow on her property without the fear of a new structure being put on or very close to the property line that would undoubtedly undermine the roots system of that hedgerow, and I'm not an arborist, but would likely have some negative impact to it.
Now I have a question. If, first of all, you talked about the views, and the views that you're referring to are not views on your client's property. They're viewed because basically the windows overlook a driveway. So the views that you're referring to are the views that exist at the present time onto the applicant's property. I understood the applicant to say quite explicitly that they were looking for a small variance or a small side yard setback so that they could place vines and so forth on the side of the garage. So that I think the intention is not to provide you with a brick wall, but some kind of vegetative relief on that brick wall. Does that really change the impact from the hedgerow? Because as far as I can see from the information that's been provided to us, I don't see any room for a hedgerow on your client's property. I see it on the adjacent property. So it looks to me as though the hedgerow, which is deemed to be valuable, and I can understand that if it's been there for a long time, and these are very large windows, a beautiful home, that looking out onto greenery is desirable. It sounded to me as though the applicant had an intention of attempting to still maintain a vegetative green view to one of those windows. The other window, it seems to me, overlooks a patio and a hedgerow anyway. So it seems to me that the view is of one window, the one you showed us, the dining room. I don't understand the hedgerow that you're going to maintain on your client's property. There isn't one. There's not one shown, and it's shown as a driveway from the property line right to the house.
The drawings provided, and I presume you're referring to the applicant's drawings, do not properly depict the hedgerow as it exists today. The hedgerow straddles both sides of the property line, so there are undoubtedly areas of the hedgerow on my client's property. If the garage were built 15 centimeters from the property line, just to excavate for the footings alone, I would believe that there would be, or to excavate for the pouring of the concrete foundation for the garage, I question whether you could retain any of the hedgerow on my client's property. You know, the question still exists as to how they would maintain the west side of the proposed second garage. And thirdly, if they, and I didn't hear this and I apologize for that, if they were to plant some sort of vegetation on the side of the, on the west side of their proposed second garage, I don't know how they would ever be able to both access, maintain, water, do anything to that proposed vegetation with the 15 centimeters that they've suggested they'd leave to do that. They would, by necessity, have to get permission from my client to access that proposed vegetation.
Okay, so your submission is then that if they moved the garage eastward so that it complied with the bylaw and it's 1.8 meter, there would be a 1.8 meter slot beside the garage, and you're happy with that. But there's no guarantee that that slot of land is going to in any way address your concerns.
It would absolutely address our concerns, because while they are legally permitted to do what they wish with the hedgerow on their property, we can rest assured that the hedgerow on our property will both be maintained and won't be undermined by any footings constructed by a garage built 15
so your
centimeters.
concern is for the health of the hedgerow as it exists on your client's property?
Absolutely, and as it has existed for 40 years on both sides of the property. But obviously concerned, we can only maintain what's on our property.
Okay, thank you.
Thank you. We'll hear now from the applicant, please. You could please respond to the
Yes,
issues
I'll try and be quickly. There were so misstatements of facts there. It may take a little while. First of all, regarding the hedge is 95% on our client's property, and we are quite happy to have you put into the conditions that we will not touch any of the hedge trunk system. I believe we're allowed to trim what's on our side, but if there are any trunk, you can see there's one little one halfway back. It's not the greatest picture, but we believe there's like one of the 30 or 40 pieces that would be on her property.
Where are we looking here?
Just in there.
So this is the lot line.
There's one little 3-inch.
This is the adjacent property.
That's right. You're looking at the client's car and house, not ours. The proposed garage would be to the left of the car, and 95% of that hedge is on my client's property, and which we will survey and stake out with a line, and only remove what is on our property that we are legally entitled to, and we're happy to have that put into the minutes, because there's almost nothing that's on Ms. Burnham's property. Secondly, with regard to the window. Well at the back of the house, not where it was shown in red. And you can imagine that there is another window just past the chimney, but that's to a hallway, we believe. Ms. Burnham's solicitor could talk to that, but we believe that the primary bay to the dining room is here, and the back wall of the garage is approximately aligned with the other window. We moved it forward, yeah. So it would not block. So there should not be a blockage of that. And as you point out, there's the full driveway width of light before we get there anyway. So but we did intentionally align the back wall roughly in line with that window, so that it does not obscure it.
So that spruce at the front, would that be removed with the construction of the garage?
Pardon me?
Is that a spruce or evergreen at the front?
That we're maintaining.
That sits in the, okay, so you'd come in around it and into the garage? Is that what you're saying? Okay, okay.
This is that tree you're looking at.
Could you tell me the distance between the corner, the back left corner, looking at your site plan, and the corner of the house? If you put the...
It's 1.65 meters. That gap is 1.65 meters.
Okay.
And your preference is that that be maintained rather than having the walkway on the opposite side of
Correct, because...
to get to the rear yard? Is that really, it's a preference issue?
To avoid that side yard variance, the garage has to move, this has to touch key corner, which means you have this dead alley in the middle, which is not very sightly. It's a dark space. It's not a good planning move, unless the garage then touches the existing house. It's much nicer from a planning point of view to have this flow around there. And then we can tuck a car here. And we're also willing to, you've made several comments.
So it allows you for, the way you're proposing allows you for more parking spaces on the property.
It allows, instead of having parking here, the car can go here, but we're also, this garage here, this driveway here is an existing driveway that doesn't need to be used. You can add into the conditions that would be just we can reduce the width of that to 3 or 4 feet, so it's just a walkway if you prefer. Because this is just an existing condition. We don't need it. This new proposal means that instead of parking cars here, we can park them here and here.
It seems to me that there are some alternatives. Your proposal is to move this, and I understand why. You've moved the garage over here so that it's separate from the house, which Heritage would obviously prefer, and then it opens up this alley.
Correct.
But I think your neighbor has a legitimate point in she's enjoyed a hedgerow along here, and her objection is basically the removal of that hedgerow. One of the alternatives may be to move this closer, not quite to the point of touching, enough to allow you to walk through, but moving it away from the property line sufficiently to allow the hedgerow to continue.
Well, how much further are you suggesting we would move it to get your approval today?
I don't know. I don't know the exact amount because it would require, I don't know where the hedgerow is. I don't know how wide it is.
Well, the hedgerow is our client's hedgerow. So we could legally we could remove the hedgerow tomorrow and the client would be unable to do anything about it. I fail to see why that would be fair, considering that the hedgerow itself is not a factor in the variance. It's something.
I'm saying I think it would be fair in that what you're trying to do is to come up with a solution that is respectful of your neighbor and respectful of your particular property as well. We have two extremes. One is move the garage all the way in which case your neighbor would be happy, and yours is move it all the way out, in which case you're happy.
Well, no, as you pointed out, there's a driveway between, and they look at green. We've proposed moving the garage 6 inches so that they can still look at green. In terms of who waters the vine, most of these vines just are self-growing. They don't need any watering. If you look at most houses in Toronto which have wall vines, they're out of control without watering. So instead of looking at our neighbor's hedge, they'll look at our neighbor's vine. But in both cases, they have a full driveway width between. Is it fair use to block this because of the type of green that they'll be looking at across their driveway width? It's not a light factor. The house is west of us, so the sun is not a factor. The sun is, if we were south of the property, I could understand what you were saying, but we're not. There's no effect on light or sun, and the back wall of the garage is intentionally located so that that window is free. And at any rate, the hedge blocks their window anyway. So it's just simply a substitution of one type of greenery for another.
Okay, so do you want to speak to the height again, given that?
Yes.
Please. And are there other examples of garages in the neighborhood that are freestanding, that have side lot lines as being proposed?
This is the zoning bylaw. It says the permitted height of an accessory building or structure is 2.5 meters if the building is located less than 1.8 meters from the residential building on the lot. So right now we have 1.65 meters, but we have our garage located 0.15 meters away from the lot line. So if we were to move the garage so that its wall was on the lot line, so that the neighbor would not be able to have a vine, then there would be no height variance, because you can see highlighted in pink, it's 4 meters in all other cases. So if we have 1.8 meters between the house and the garage, then the height variance disappears. That's why, in terms of planning sense, you can intuit that the planners like to have distance between the house and the garage. Heritage likes to have distance between the house and the garage. Heritage and planning both support the application.
We do not support the application, we simply have an objection to it.
Incorrect. Another statement of non-truth, and I can prove that as well. This is email correspondence between Robert Ursini and myself. He's the planner. He says, "Hi, Stuart. Thank you for contacting City Planning. I have reviewed your proposal and do not have any issues with the variances requested."
It's not support.
I would consider not having issues to be pretty damn close to not to supporting at any rate.
Close to now. Thank you.
So we have no objections from planning. We have no objections from heritage. We're doing generally what both of those departments agree to do.
And what's your position on the letter from the
The letter from the ratepayers simply says they'd like us to get along, and you have ample documentation of the 2 or 3 months worth of trying to get along has led us to be.
So, sorry, your time has been completed. With respect to standalone garages?
Want an example?
Yes, please, with the setbacks that you're requesting.
House. This is a brand new detached.
And where is this?
I'll show you where it is. So this is our house.
Yes.
This house is right here, and the garage faces Lamport. Literally, there's 4 houses between this garage and where our garage is going, and it's almost exactly the same condition. And that was just approved. It must have been just approved because it's just finished construction.
All right, thank you. Do you have anything else that you'd like to add?
If you go down the street, this is not a street of garages in the backyards. The garages face the street on both sides of Lamport, either attached or detached. It's more common than not. So we're not, I believe that's why the planner so supports this, because there's no breaking in precedent. In fact, we're one of the only houses that doesn't have a garage facing Lamport. So we are not setting a precedent. We are the last party to the table. Thank you.
Okay, do you have any other questions?
I don't know.
Okay. Okay, we're in committee. Discussion or a motion? I have some concerns about the existing driveway remaining should this be approved.
I do as well. I believe that the appellant has raised some legitimate concerns. And I think that the solution is one solution that could vary a bit. I wish, in fact, the garage were moved further to the east to provide for a more substantial landscape strip. But either way, my approval on this would be dependent on providing greenery along the west face of the garage as a way of addressing some of the concerns that have been raised. I appreciate that the garage needs to be separate, and I agree with that. I appreciate the need to not have a slot between the house and the garage that goes nowhere. That's, for one thing, it's a dangerous situation aside from being ugly. And I share your concern about the existing driveway. So
And I'm not sure the impact, like if we were to provide for condition with respect to vegetation,
how it
which is
gets
hard
maintained.
to enforce.
Yeah.
But I'm not sure that the moving the garage further away is necessarily going to change much of the impact on the adjacent neighbor in a real sense.
So do you want to move the motion?
Do you want me to move one?
Yeah, and let me see what it sounds like.
Okay, so prepared to move a motion to approve the application with the conditions that the existing driveway be converted to soft landscaping and that vegetative screening shall be planted along the west side of the proposed garage.
You might want to say, there's two driveways, you might want to say the east one.
Okay. I was going to say the existing garage noted on the site plan filed with the committee.
Okay, the applicant's point is
Yeah.
there's two driveways, and you mean the one on the east?
So the east, yes.
Yeah. I'm prepared to support that.
Okay.
Thank you very much.
So the application is approved with those conditions. Thank you very much. Was there? Okay, sorry. We'll reopen to add a heritage condition that prior to the issuance of the building permit, drawings be submitted. So do you still second? Okay, thank you.
The next application is item number 3, 66 Harper Avenue. This is an application to construct a new two-story detached dwelling with an integral garage and a rear second-story deck. 5 variances under the new bylaw. And we have before us on this application 3 renderings of the subject property. Urban Forestry requesting their standard condition number 2. We have correspondence in opposition from 91 Hudson and 70 Harper, and a 7-signature petition in opposition signed by area residents on Harper and one on 2 Valley Drive. Okay. Okay, I'm just going to hand a letter.
No, you can hand it to staff there, please. Thank you.
So this is a further letter of objection from the owners of 62 Harper. You only have the one copy for us?
I think we've come to...
Oh, it's the same as the one similar to this other one. Good morning.
Good morning. Jonathan Binskowski here on behalf of the owner. I believe we've come to a compromise with the appealing neighbors.
Okay.
So just to quickly run through the changes as they are reflected in the public notice.
Yep.
So variance number 2 and 3, which relates to the main wall height.
Yep.
We are taking off 2 feet. The request will now be for 8.69 meters.
This is variance number 2?
Number 2 and number 3.
Yep.
8.69?
8.69. Variance number 4, which deals with the proposed length of the building. We are again taking off 2 feet. We are now at 18.91 meters.
Okay.
Variance number 5, that relates to the GFA, and I'll go over how we appropriated that reduction in the GFA after the consultation with the neighbors, is now a reduction to 340.61 square meters, or 0.694%.
Okay.
So we actually had a very fruitful discussion with the neighbors. In the end, it didn't start out fruitful, but it did end up fruitful, where we were able to come to this agreement. Now, just to go over how the changes will be reflected in the plan itself, because that was important as to how it would be perceived from the adjacent neighbors.
Okay.
So the request for the original request for length dealt with the first floor itself. The proposed second floor of the dwelling was essentially in line with the zoning bylaw, except for a small bay window. So what we have done, let me give you the better one actually, sorry, my apologies. This is the better one because it shows it on that adjacent property. So what we've done here, okay, is this 0.6 meters here is actually an inset bay, call it a little breakfast area. That 0.6 meters is to remain. Where we're going to take the 2 feet off of the length is actually in the brick mass here itself. So that is the corresponding reduction in the GFA that relates to the depth. So this bay window here will move in 2 feet.
So you're brewing the wall back.
Correct. The actual mass as it relates to the neighbor to the south is where the change is going to occur. In terms of the second floor, we're essentially in line except for a small bay. That is to remain as it is.
Okay.
So how that will correspond to the design.
So the portion that you've taken off is actually just going to affect the entrance hall and the living dining room, right?
Incorrect. It's at the rear of the
back?
property.
Okay.
The front is to remain. The concern was from the neighbor to the south, how it was projecting into the rear yard.
All right,
So
okay.
the actual projection is going to be taken off of the rear.
All right.
And we could make that a condition if you so see fit, because I understood we could fiddle with it if you wanted.
No, that's good.
So how that is going to actually be reflected in the design itself is right here. So this portion here is that small little breakfast nook area. The 2 feet again is going to come off of the mass here. It's going to create a little havoc over here with doors, but we can figure that out after. So the length is going to come off of here, and it's important that it came off of there because that's what's going to correspond to the GFA, which means we can't fiddle with any other portion of the bay and move that to allow for a door. Okay? So just to go over one other quick thing, which was a concern from the neighbor's letter that was sent in a couple of days ago. I'm not sure where the idea of a second floor balcony came in. That has never been proposed. It's not on floor plans. It's not on the elevations. It is a flat roof. As I'm sure you know, anything over 4 square meters above the first floor requires a variance anyways. That's not a proposed deck anywhere above the first floor of this dwelling at all.
Okay.
Okay?
Door back.
So in terms of the variances that are before you, I think after consultation with the neighbors, reducing that length, the actual north portion of the dwelling has always been in line with the zoning bylaw. It's actually below the 17 meters in length. In addition, correct, the existing.
Just one question.
Yes.
So is the basement level pulled back as well?
It will all come in, yes.
Thank you. Sorry to interrupt.
Yeah.
How did you adjust the height?
Well, what we're going to end up doing is taking a foot off of the first floor to ceiling, and a foot off the second floor to ceiling, and making them a little bit more of a coffered ceiling on the second to make it look higher.
Okay.
So it's going to lower the eave height, which was the main concern of the neighbors.
Because my only point was the drawings are fine except for the perspectives, which are misleading. The first perspective.
The renderings?
Yeah, and the third one, there's a mansard third piece on the top that doesn't show on those perspectives at all, at least as they're reproduced in our agenda.
Sorry, one second. I did not notice that.
Might be the way they were copied, but they kind of look fuzzy in a.
It looks like it's part of the tree. Here.
I think it's not
see, it's misleading. That looks like it's the top. It
Oh.
does there. See, it's lost up in there
Yeah.
because it's dark. And here, it's lost in here completely. Yeah, that's,
Yeah,
yeah.
I
And
think
your
what happened is-
elevations are fine, but.
Because you were sent the black and white ones, it's tougher to see the variations of the roofs itself. Yeah, so we're going to actually bring that roof height down. Sorry, the eave height. The other thing I think is important to note, the actual height of the dwelling itself was always in line with the zoning bylaw. There was no request for the overall height of the dwelling.
The side walls.
Correct. Now, that part of that is, even the existing proposal, there's a 1 meter grade change from the front to the rear. So actually at the rear of the property, the main wall heights that would face the rear is actually 8 meters, which is well below the zoning bylaw. But yes, we are bringing it all down correspondingly with that.
Yeah, so perhaps we should just have the neighbor take the stand and just tell her she concurs with this. And I just want to, are we going to have this tied to some plan, or?
The problem is the architect is away, but because of the gross floor area and the length, we're going to be tied to that footprint anyways.
Right.
And because we don't have the side yards, we're in compliance with that. That's why I thought it was important to make sure I showed you where I was taking that GFA off and where it was appropriated, because there's really nowhere we can move anything besides that.
Great, okay.
Okay, thank you. I represent the neighbors on Harper Avenue, quite a few of them.
Okay.
And I just want to point out that...
Your name and address,
sorry.
Ellen Klassen?
Sorry, no, Carly Vint Reed, 62 Harper Avenue, next door, south side of this...
Pull that mic down a bit.
Thank you. He's a lot taller than me. Now I really feel like I'm shouting. So I just wanted to point out that we are on Harper Avenue in Moore Park, and we really pride ourselves in coming from a neighborhood of beautiful established homes that have a lovely line to them. So one of the reasons we wanted to have this discussion with the builders and the new owners is to make sure we keep in that line, and that's why these variances were important to us. Secondly, we also pride ourselves in being great neighbors, so we really appreciate the new owners coming and being part of this discussion. We have come to a very good compromise, I think, of 2 feet and, on the height of the individual floors, and the 2 feet off the back. We would also like what you said to be able to premise this on a new plan as well. So, but we appreciate the compromise and thank both the owners and Jonathan.
Working together.
Thank you.
Thank you.
Okay.
Okay, any further questions for Mr. Minkowski, or are we ready for a motion?
I'm very happy with the amendments that have been proposed, because they address some of the concerns and uncertainties I had with respect to the application, given the character of the neighborhood. There are certainly some new builds that have gone on in that neighborhood, and there's one a little further down that looks quite large in the context of what's currently there. But if there's no further discussion, I'm prepared to move a motion. So through you, Mr. Chair, I would propose to move a motion to approve the amended application. That's the amendments, including an amendment to variance number 2 to reduce it to 8.69 meters, an amendment to variance number 3 to reduce it to 8.69 meters, an amendment to variance number 4 to reduce the length to 18.91 meters, an amendment to number 5, variance number 5 to reduce the floor space index to 0.694 or 340.61 square meters, as I believe with those amendments, the application does meet the tests under the Planning Act and reflects the character of the neighborhood.
Urban forestry number 2.
And urban forestry number 2.
Okay, seconded for that.
I second the motion. I'd also like to compliment both the applicant and the neighbors for excellent collaboration. That's one of the reasons we ask people to go and talk in the hallway in the hopes that something like this will happen. So congratulations.
Okay, unanimous approval. Thank you.
Can we do BLOOR? Yeah, the one we stood down earlier so I could talk with them. There was no number 7?
Yep, that's right, because that was unopposed. Okay, so next application we're going to do is
5?
Item 7, which is 1261 Bloor Street West. This is an application to convert one ground floor residential unit located within the existing 3-story mixed-use building into a coffee/ice cream shop, restaurant use, and the 8 residential dwelling units and commercial uses on the ground floor will remain. And we have on this application 3 photographs of the subject property and a correspondence and concern from 420 St. Clarence. That's all we have.
Yeah.
Okay.
Again, Jonathan Binskowski. I've had some discussions with planning. This is going to be subject to a rental housing demolition application. My life's been a little bit hectic. I had a little girl 2 weeks ago, so I haven't had a chance to get it in. But I've been speaking with them. I really just have to get it in. Basically, this is not the vision for the city and not how planning should be, having residential units located behind existing commercial uses located along Bloor. The owner actually purchased this, leased the unit out to his friend. His friend opened up a shop. Licensing came and said, get a license. We went in for a zoning review. They said, this is actually a residential unit. I said, well, great. So here we are removing that residential unit. In terms of some of the concerns from the neighbor itself, the best thing I can say to that is if people are putting cigarette butts out there, maybe she has to call licensing. It's really tough because, again, zoning by 569/2013 does not encourage residential units like this behind existing commercial uses located along Bloor Street.
Okay, thank you, Mr. Binkowski.
I have one question. Can you tell me how it's an ice cream shop, right?
It's 2. So I can actually show you here quickly.
Actually, my question was, how are they serviced? How do you get supplies in and
Lane.
out?
Laneway.
Lane?
Yeah, correct, laneway.
From that one entrance? There's 2 entrances. One goes upstairs and one goes downstairs.
Yes, it would be off the laneway and they walk it in through the side. So it's a half coffee shop, half ice cream shop. It's kind of the same use. So they would access it.
So the truck's on the laneway?
Yes.
And then do you take it in from?
The side door. Off of St. Clarence.
Off the street, okay.
Not off the laneway.
Not off the laneway. The parking would be on the laneway. You would access the actual use itself off of St. Clarence.
Thank you. That's what I wanted to know.
Okay. Okay, we ready for a motion?
Yep. Yeah.
I'd like to move approval. Mr. Chairman, I'd like to move approval of the application. I think it's a relatively minor application that, as the applicant indicates, is any conflict seems to be something that planning in subsequent years has addressed and intends to address. But I think in this case, the 4 tests of the Planning Act are met, and I'm happy to move approval.
I'll second that.
Okay, you have unanimous approval, and congratulations on the addition. That's an addition. You don't have to come to Committee of Adjustment.
No. Thank you.
Okay. So going back to item number 5, 447 WINNETT. Neighbors on this application? Is there still opposition to this application?
No, hope to be another example of working it out in the hallway.
So let me just, this is an application to construct a new 3-story detached dwelling with an integral garage, and there are 5 variances under the zoning bylaw. And before us on this application, all we have is 5 form letters in support.
7 should be.
7? Okay, so I guess you have a couple more to add. 1, 2, 3, 4, 5.
Yeah, so my name is Marin Zabzuni. I am the agent for 447 WINNETT Avenue. So the neighbors, the direct neighbor had some questions about the plans and designs that we talked through the hallway. They're satisfied now with the application. We have worked closely with city planning too on this design to make sure it's respectful to the zoning bylaw, the Planning Act, and the neighborhood and community. We've spoken with many neighbors as well and have obtained 7 support letters. And we can go through the variances and the rationale if you would like.
I just have a question. I don't know if committee members want to. The platform at the 3rd floor, which is double size, you're allowed 4 meters. This is 7.95. Is that off of a bedroom, a common area?
So it's at the 3rd floor at the rear, but it's within the roof. So you don't see it on the side. It has privacy. You can only see it from the rear elevation. So because the 3rd floor is a lot smaller than the 2nd, and it's just, yeah.
Okay. And that's at the rear, correct? it's off a common area, but I just, sometimes if it's off a bedroom, it's someone place to go have a coffee or.
Pretty
whatever.
much, yeah.
But when it's off a common area, sometimes the concern is it's going to be a place to have a party, and there's those issues.
No,
So why is it, I guess the reason it's oversized is it fits within the roof line?
Exactly. And even within that, it's still quite far back from the extension of the roof, even so. So it's very mild in that respect.
Any other questions?
No.
Okay, ready for a motion?
Through you, Mr. Chair, I believe this application is indeed minor, and I'd like to move a motion to approve it.
I'm seconding the motion. I'd like to actually say that the solution for privacy of the deck is an excellent one. So often we're forced to place landscaping or glass screening around an already relatively small space, which I'm not sure always works. This case, you've actually built it into the roof form, which is a good solution.
Thank you.
Okay, you have unanimous approval. Thank you.
Thank you.
Okay, next application is item number 17, 168 Hillsdale Avenue East.
So
The applicant, please come to the podium, neighbors to the front row here. This is an application to alter a two-story detached dwelling by constructing a rear two-story addition, a finished basement, and a rear deck. And on this application, we have before us a copy of the package that the applicants provided to the neighbors of Hillsdale Avenue East. We have right-of-way management memo from them, but whether the property, the pad is on private or public property or just on private property. And we have correspondence in opposition from 10 form letter opposition, form letters in opposition, and another 5 letters of that. We have 10 form letters, and then we have, just numbers. We have, I can read out the date of the addresses if that's relevant, but I think we have enough letters here, including both, looks like both adjacent neighbors. 166, do we have 160, 170 on the list? Is there a 170? I don't see 170. Okay. Good morning.
So, good morning. My name is Luz Elena Espinosa. I'm the agent for Somerwell. The owner here of the house is Jason. And we spoke to the neighbors outside, and they still opposing to our proposal. We have reduced some of the variances request, but I want to.
Okay, why don't you make a presentation, tell us about the changes you've made in good faith, I guess, to try to appease the neighbors.
Yeah.
And we
So
can go from there.
the first 3 variances are existing. So they understood that part. The first variance, I spoke to Lynn yesterday from the transportation, and she was okay with what we are proposing, because we clarify that the permit that we have is we are going to keep it, so we have to deal with them for the permit to continue with that permit.
Is that pad going to be, is that partially on public property, or is it all on?
Yes, it's more in public property, and we will continue with that, and they are okay.
Yep.
So that one will be okay for us. So the 4 variants, the neighbors are more concerned about the depth of the building, which is the number 6 variance that we are requesting.
0.7 of a meter more than permitted.
Exactly. So we say that we can reduce that to 17.39, which is half of what we were asking for. So that will reduce also the variance number 4
Floor space.
to 0.66%. And
How many square meters?
it will be 196.3.
So you've taken off like 4 meters approximately,
Yeah.
3.7 meters. Okay.
So that will reduce the number 4, and we are also, they are concerned about the height of the building. I explained to them that this is a very minor variance in our point of view. It's only the side walls.
Side walls, yes.
We are proposing a building that is lower than what is allowed.
Right.
In terms of building height. So for us, that represents a minor variance, but the impact that they say is because it's a flat roof. We have some photographs here of...
Excuse me, sorry to interrupt. I don't understand what you just said. You said you're asking for a height that's less than the bylaw. The bylaw is 7 meters, and you're asking for 7.8 meters. It's
the side walls.
Right.
But we are in total, the total building height is less than what in reality, it's not a variance for us right now,
Yeah, you don't
but I
have a
want to
variance
point that out, that in total, the height of the building is less than what is allowed.
But the sidewalls are higher.
The sidewalls are higher.
Thanks.
Yes. So if you see the photographs that Jason passed, photographs of flat roof done in the neighborhood. Where are they? So we believe that that is the tendency now in the neighborhood, and the people like to have flat roofs for many different reasons. One is to have high ceilings inside the house, and since the height of the whole building is not even within the bylaw, the allowable, so we think is a minor variance. Also, we have there some previous COA approvals, and I have for floor area, for height, for side yard, and depth is some addresses there in the neighborhood that they have approved bigger than what we are asking for. So we consider it's a minor impact in the neighborhood. We have a very long lot also. So yeah, they say that is very deep, the building, but in reality, the variance is just a 0.07, yeah, I forgot how much it was now.
0.39?
1739, yes. So it's 0.39 meters is the variance. And we still have a big backyard.
Okay. Are the objectors?
Okay. Does that summarize or finish your submission, and you'll have a
Yes,
chance
I
to
think if you
respond
have
to
any
neighbors?
questions, yeah.
Okay. Okay, so let's hear from the neighbors. We have a spokesperson, I hope. Who's speaking for the neighbors? I don't think we need to hear him. Mr. Keeper, can we keep it to 2 speakers, perhaps? 3? It's not going to be saying the same, just different perspectives, not just repeating the same thing? Okay.
Okay. Thank you.
Good morning. My name is Wendy White, and I am the owner of 166 Hillsdale Avenue East, which is the house immediately west and downhill of the applicant's house. This area of Hillsdale Avenue has many older homes, and it's a long-developed area with very mature trees and a strong community. I have lived in this house for 40 years, and over this time I've invested many thousands of dollars in improvements, maintenance, and the creation of a large garden area. The plans proposed for 168 will have a very significant negative impact on my house and property, and I am strenuously opposed to the variances, and as a whole, they are more than minor. The bylaws are designed for larger lots than our lots are, regardless of the depth, and to grant variances works against the purpose of having them. I believe that this addition and renovation as proposed is too large for the property it sits on. It does not fit the more typical style of house in this neighborhood, and it will diminish the environment of the immediate properties by restricting sunlight, view, and green space or amenity space. The area of South Eglinton is not well served by park areas and is being drastically altered by the large number of high-rise condominiums and office towers. Preserving the available green spaces, trees and gardens is an extremely important part of maintaining livable areas and creating community amenities that benefit the environment and the residents. There are a number of areas of this written comments that I'm going to leave out for time and as a result of the discussion that we did have with the owner and architect at the meeting today. But I would like to go to the third page and talk about variance number 4. The floor space index, I'm sorry?
It looks like variance number 4 is on your second page. On your second page?
It may, yes, I'm sorry, I have a different size of font here I'm looking at. Second page, yes, floor space index of 200 square meters. Although the allowable FSI is 0.6 times the lot area, even this floor space is considerably greater than that of the other homes in the area, and especially the houses closest to 168. In fact, the proposed addition and renovation would almost double the size of the existing house. And it's like having another house in the backyard, and it creates not only an extreme renovation for the area, but an undesirable precedent for the future. On the photos, and all the photos are printed randomly, so they're in different places, but the one that shows the umbrella in the back of the house, you can see where the two houses are very close to the similar length, and with the addition stretching out, it will come out almost to the area where the chair is situated.
It's sort of hard to see from the perspective. I see that's the subject property, is the one with the umbrella and the small addition.
Yes.
So that's the subject.
That's not an addition. That's part of the original house.
Okay, but it's clad in aluminum or something, other materials. But it's hard to see where that matches with the adjacent houses. It's easier to see on the survey and on the other plans that have been provided, including the applicant's plan on page. I think the one that shows it the best is page A1 of the applicant's package of how much farther it goes.
Yes.
That shows us. It's harder to tell from the picture.
So on this particular...
If I might, the picture that might be more instructive, there's the one with the umbrella, but then there's one with snow in the backyard. And
yes.
It's got a bird bath.
That's the one that's up on the screen at the moment.
Okay, where does the proposed expansion, you're saying it goes almost to the chair?
It goes to
where the chair is.
Right about here.
Okay.
In this case.
Bird bath.
So it would rise up from the retaining wall up here and come out straight from the neighborhood house.
And
so
does the retaining wall extend on your entire property line?
From the back of the house all the way through to the back of the lot.
Okay, thank you.
And
the bird bath and the chair, that's the subject property, that's your property?
That's my property. And the retaining wall behind it is also on my property.
Okay.
I'll go on to the...
I guess you realize, though, that as of right, they could build to, and they've cut off a little bit, 17.7 to 17.39. So they're only like 0.39 over what's permitted.
They are now suggesting only a small amount over what's permitted.
But what I'm trying to suggest is even if they build to what they're entitled to, it's still going to extend substantially.
It is still going to be substantial, but that's really the reason why any amount above the allowable limit is undesirable.
Did the applicant share with you this drawing that has red dotted, it shows the size of the house that they could build?
Yes.
Okay.
We had that discussion earlier this morning with the builder and architect, or the owner and architect. I'd like to speak to variance number 5, the maximum sidewall, which is the part that is going to be most visible to me. And again, we've mentioned this a little bit, but even though the height of the building is within the allowable limits, with a flat roof, this is not going to be just the peak of the roof that's within the limits. It's going to be the entire length of what they originally proposed as a 17.7 meter long house. So the effect of this on my property is this huge wall, which is 31 inches over the limit. And this is going to have a very large negative effect on the amount of light that's available, the airflow in my backyard, the whole aesthetic quality of the property, and environmental considerations as well, such as drainage from one property to the other. It will effectively be like having a 3-story building next to my property because of the fact that the retaining wall is 3.5 feet high.
Ms. White, if you could, especially since I'm advised there are going to be 3 speakers on this application, you've gone into 7 minutes already. If you can,
I need to, yeah, I will just.
You didn't read the whole letter out too, so.
Thank you. I'll just skip to the end then. So if you look at the photographs, you will see that the impact on the back of the property is my primary concern. For the last 4 years, I've held a midsummer garden party in the neighborhood. It's been well attended. Neighbors come to see the garden. They share plants, talk about gardening ideas, and socialize. It's also the area where, on the patio, where I do entertaining, and all of this will then be in shade all morning long, all the time, and in reduced light even when it's not sunny. The cost to me to preserve a garden, given the amount of shade, would represent many thousands of dollars, as there would have to be significant changes made to the garden area. And I will leave it at that.
Right. But you know, that would still have to happen even if they were to build as
I know it is.
15 feet. Right? So we're looking at the difference of what they're permitted.
I understand that.
These are very long lots. And
it is a long lot, but I should mention that the back of the lot is very heavily treed, and that's not where my garden happens to be because it's too shady for it. So it's the neighbor's garden is more accessible to them because there aren't big trees there. I did also want to mention that in order to build this house, they will have to remove a good-sized, mature dogwood tree, which is a really beautiful flowering tree, and that's going to be closer to the eastern side of the property, but that will have to come down if they build the property as they plan to.
Right. Okay, thank you, Ms. White.
Thank you for the photos. They're very helpful.
Oh, good.
Okay.
Thank you.
Next speaker.
Apologies for the setup. Seems everyone has tablets when I go to North York, so I'm starting to use tablets these days.
Yep.
They
like using too.
technology.
Thank you.
My name is Al Keevy. I'm representing South Eglinton Ratepayers and Residents Association today. We're very often called upon by our members or residents to stand up with them and talk about the issues as we see them. I did put together a correspondence raising some concern about the staff transportation matter, but I understand that's been dispensed with today. I'd like to talk very shortly, if I can, about just noticing the clock. I'm now used 9 minutes, so so anyway, that's...
That one says 0.
Yeah. Oh, okay, there we go. Yeah, I got to watch the clock because I tend to talk too much. So this is a shadow impact analysis. It's not complete. It's not a full sun and shadow study, but I think it'll shed some light, so to speak, on the lack of light with the proposed property. First chart or diagram here shows a group of houses that this is, well, I would call it the nearby properties. It's not the whole of the Hillsdale arena, but it's really the three properties I'll focus on, 170, 168.
Yeah, 170 is, are they in opposition? Because when I was going through the opposition letters and petitions, I didn't see 170 represented.
I understand they're rent.
174.
Oh, sorry, my apologies.
Oh, so right next door, there's no 170 or 172, it's 174?
I believe they're renters. Are they renters? And they've not weighed in on this.
Oh, notice.
Oh, they did. My correction on that.
Sorry, what was the answer to that?
They did send in, the renters did send in a letter.
Well, okay, would the owners not have been given a copy of the notice?
Yes.
Okay, so next door is 170, there's no skip. So there is no 170, there's no 172.
Yeah, my apologies. I just was trying to label these charts here.
Just wanted to understand that as we hear from you.
Yeah. So my shadow analysis really focuses on these three properties. It's mostly the abutting properties that feel the brunt of increased shadow. The first chart shows the existing dwelling looking at it from the east, from a westerly direction, looking at the subject property and also Wendy's property at 168 as well. It shows the shadow at a particular time. I believe it's in June 21st as well. I can't read it very carefully. But it does show the existing condition as well. I've marked out the garden. The garden is marked out in green, and that indicates, I think of it as an amenity space. We have typically with properties, we very often have two amenity spaces. One is a patio area, and the other is very often a garden area as well. So it's really unshadowed in terms of the garden area. The patio, which is in the backyard, is largely shadowed. That's going to be the case with the proposed as well. This chart shows the increased shadow impact with the proposed dwelling. And you can see that the increase in shadow is really quite dramatic. That shadow really comes from two sources. One is the depth. You know, this is showing the 17.7 meters. I didn't realize that we were going to be reducing that. But any increase in depth or decrease in depth has a direct impact on the amenity space. So if the applicant is good enough to give, split the difference, why don't they respect the bylaw? 17 would be appropriate.
Good thing you brought that up, Mr. Keevy, because I was going to say is to what extent are those shadows, which I agree are quite dramatically impact on Mrs. White as a result of the as-of-right condition?
Yes, yeah.
A good chunk of it, if not most of it, right? So
yeah, I would say that
what we're here today is not to look at this whole addition, which almost looks like doubling the house. I agree with that wholeheartedly.
Oh, sure.
But we all acknowledge that as of right, the applicant can build almost, aside from the height, which is over like little more. But the altered depth and the floor space index, the floor space, they're only 4 meters over what they're permitted to build, 4 square meters, and the height is only 0.39 of a meter, which is, that's feet about.
Yeah, they're asking for roughly about.
I agree with you, and this is a great depiction, but
yeah, they're asking.
I think we have to take notice that the majority, the lion's share of this,
yes, yeah,
results in the answer right.
So they're asking for about 0.7 on a 10-meter increase. So you could say that. What is the quick math on that? It's about 10% of the shadowing is due to that. I mean, my argument is that if they're prepared to give a little bit, why not respect the bylaw? There clearly is an adverse impact. It clearly is impacting an amenity space, and I'd ask that that be under consideration. I didn't have a chance to show today, but what you do see is the squareness of the addition contributes to the shadow. If you can imagine that we had an addition that was not a square roof, but the addition was a peaked roof, and unfortunately I didn't model that, what you would see is a reduction in the shadow, not in this particular case, not so much impacting the garden, but certainly impacting a little bit of the backyard as well. So I think that certainly demonstrates the impact of the shadowing.
Right, but I think we have to look at what's permitted as a variance, as a minor change from what's permitted. I want to look at the plans because I saw somewhere in one of the letters that mentioned that there's 2 eating areas, 2 family rooms. So the question is whether a further reduction, bring it within the allowable limit, which would still have an impact, whether that's an unreasonable impact on the neighbor, on the applicant, because, but if they have all these generous room sizes, that's where one of the, there's an issue now whether we should be seeing the internal for privacy concerns, but that's where you want to look to see whether it's overly generous, resulting in an impact on the neighbor.
If I can, I'd like to jump to the last in my little shadow impacts analysis. This is not Wendy White's property. This is the property on the other side. And at the same time of day, we are seeing a bit more. This would be the evening. This would be 4 o'clock in the afternoon. We are seeing very significant shadowing here. It shares the same issue, both in terms of the increased depth, 0.7 over, or 17.7 versus 17. And you would, if you can imagine here, that if you peaked that rear addition, you actually would yield more light in the backyard of that particular property, even probably in not so much in the patio spaces that they've indicated, but certainly it would share more adequate sunlight as well. These are protections that are offered under the Build Form 3.1.2. We don't have variances to argue for sunlight and shadowing, but I hope today that we see that there is clearly an adverse impact.
The adverse impact on 170 or 174, as far as I know, that neighbor is not here objecting. They haven't written in, and maybe that's just a function of the fact they're waiting to get this approved, and they're going to do this thing, double the size of their house, double the value of their house, and everyone's happy on International Happiness Day.
Yeah. Well, one of the roles of residents associations is to speak for residents who can't show up, and clearly there is an adverse impact, at least for not the current resident, but a subsequent resident of that particular property. Thank you very much.
Thank you, Mr. Keevy. Okay, I understand we have one more speaker. Is that Mr. Brown?
Okay, good morning. Still morning, I think. Yes, my name is Robert Brown. I live at 88 Spadina Road, Suite 212, and I'm here today representing Mr. David Stimson and the neighbor at 164. Mrs. White and Mr. Keevy have covered a number of the issues, and what I'd like to do is perhaps focus more on the official plan, and particularly how this proposal doesn't meet the intent and purpose of the official plan, particularly as it's been modified by OPA 320. So first, let me just put up a drawing number A1. So if you're looking at this drawing, which is basically the site plan, what you see is the existing condition is basically in line with 168 and is it 174 is the one to the, or is it 70? To the east. So what you can, so what you can see is that the existing conditions are quite modest. Obviously, the zoning bylaw allows an expansion to the north, but what I want to talk about is what is the prevailing character within the neighborhood, particularly that neighborhood which is on Hillsdale between Redpath and, say, the equivalent of Dunfield Avenue, even though it doesn't intersect. So that comprises, 50, 60 homes. And I also did an analysis of what we might call the broader neighborhood as defined under OPA 320. So I took all of Sudan between Yonge Street and Redpath and all of Hillsdale and all of Manor Road. And that existing condition indicates that the average FSI of all of the properties there is still less than 0.6. And the other item that is important is that the median FSI is less than 0.6, and in actual fact it's less than 0.5. So the existing condition at 168 is that they have an FSI of in the mid 0.35, 0.36, and they have a gross floor area of about 103.6 meters. And the bylaw allows a material significant increase. And we believe, and the position of Mr. Stimson and certainly Mrs. White, is that just going to the allowable FSI, going to the allowable depth, creates a home that is out of character with the existing neighborhood, but as you say, it's within the allowable limits, the performance standards that are set within the bylaw. Any incursion beyond that, I believe, doesn't meet the intent of the official plan, and I don't believe it meets the intent of the zoning bylaws. Now, we had a meeting last night, and we were talking about it. I said this is like when we develop the city develops a bylaw or a recommendation that the maximum height limit on a building is 80 meters. The development industry says, well, that's not the ceiling, that's the new floor. Well, here, the applicant has considered that 0.7 is just where I can start. Our position is, in this neighborhood, it should be where you end, because the prevailing character is well below what's allowed, and it's certainly in both terms of FSI and GFA. And I would draw your attention mentally, as I know you've all read the plan, this is covered under Chapter 2, Section 2.3.1. Second paragraph basically says neighborhood stable, shouldn't be egregious increases against what the existing character is. Also in official plan 3.1.2 and on pages 3 to 7, policy 1D and 3D basically reinforce that same argument that the prevailing character, the most common built form character in the neighborhood, should be respected. And of course, in the official...
You don't just, like the applicant has given us a list of applicants who come to the C of A, like you say, they look at it as the new performance standard as a ceiling, not a floor. I don't think the analogy I think you have a better argument on a single family than you do on the high rise, because the high rise...
Oh, yeah, so I'm just saying, I was just using the high rise as a sort of to me, it's more visibly imaginable.
Yeah.
But in terms of the official plan policies under 4.1.5, and the four of us have read those more times than we'd probably care to in our life, but it really, it establishes a benchmark that I believe should be adhered to. It's not like, okay, the sidewall should only be 7, and let's make it 7.8. The depth should be 17. Well, let's make it 17.39 or 17.7. When you've got an existing condition that is quite materially different, I think there is a greater requirement to actually stay within the bylaws. Now, I did, provide a little histogram. I did take into consideration all of those C of A decisions that are referenced by the applicant. Note that those C of A decisions, by and large, were implemented prior to the introduction of the OPA 320, and it's obviously City Council has made a policy decision to try and curb the excesses that were applied for and in many cases approved. Well, this is a new planning environment. There's new legislation in place, and there's new planning regulations within the zoning bylaws.
So I understand your argument of prevailing character, and it's a very good argument, but you would agree with me that our role here is to establish or evaluate the increase over the allowable, notwithstanding it's a question of creeping gradualism or whatever, but that's what we're discussing.
That is one of the tests, of the 4 tests.
Correct.
Where you as panel members say, well, okay, I'm looking at the bylaw regulation that says X, and they want X plus. What I'm saying is there are 4 tests, not just is this considered minor relative to the performance standard. I'm saying I think you should consider and evaluate this application based on, does this meet the purpose and intent of the official plan, particularly as it's been amended by OPA 320. And my recommendation would be that it does not. Now, God, have I been speaking for 7 minutes?
Yes, you have.
Oh, sorry. We did have a very civil and constructive discussion with the architect and the applicant outside. I believe that there are opportunities for internal redesign of the dwelling, and I think that if this item would be refused and or deferred, that there actually would be a much better proposal brought forward to you at another meeting. So I ask you to... Or
they can build within
Right, they could build within it, but I'm just saying that there seemed to be a civil engagement process that has been started, and I believe that rather than approving this application, that you either defer or refuse it and allow the applicant or the neighbors to actually reach an acceptable solution.
Yeah, well, at this point, we're not going to defer it. We've listened to it for half an hour, and...
well, then I will defer to you, but with my recommendation would be to refuse it because it fails to meet at least one of the 4 tests, and probably 2. I believe it also would fail the test as it represent an appropriate development of this site in light of its local context. Thank you very much, and I'll be open to questions.
And when we hear back from the neighbors, I'd like to hear about how much space you need in terms of looking at. We look briefly at the plans. There's the family room, there's living rooms, there's various eating areas. We're just looking for that plan again. Was that in the handout?
Yeah, well, I don't know whether that was a question or in a prior life I was a draftsman, and I'm not about to suggest the architectural solution, but I do believe that there are readily adaptable modifications to that second floor and to the basement, which will allow the owner to achieve all of his living space objectives.
Bedroom. Okay, thank you, Mr. Brown.
Okay.
That's a second floor.
Yes, I guess. So how many washrooms we have here? Three washrooms.
4 bedrooms.
4 bedrooms. And ground floor you have. Yeah, okay, thank you. I'm saying you have a family room, a breakfast room, a kitchen, and other than a dining room.
He's got that on this.
You know, so we have that. We can see. Thank you. Can you just go, I guess, go to the podium to make your submissions so we get picked up by the camera?
Okay. So as we said before, we reduce the variances.
Mm-hmm.
So in reality, the variance that we are asking for the length is minimum, minor variance as we are requesting.
Can I just ask how you, in terms of the plans, what did you do to decrease the size? Is it
I have to decrease as
taking that bay window
back
out? Is that what it is?
That doesn't include, is not included in the depth.
Length, okay.
So what I did is decrease the family room by 1 foot, and also the problem is not only the first floor, because the first floor you can reduce it probably like you say, okay, so the family room will be, the problem will be the second floor. The bedrooms that we have right now are 8 feet 6 inches wide, which is very small. The minimum by code is 8, and we are doing it 8.6.
But in reality, you have 4 bedrooms and 3 bathrooms on the second floor, right? And one of the bathrooms is huge. The master bathroom is really.
There we are reducing, if we are reducing the 1 foot, we're gonna reduce that bathroom 6 inches, because we have to have a space to walk in between the vanity and the shower there. So we can reduce that 6 inches. Then we reduce the 6 inches in the master, and that is what we are doing in order to reduce the length.
Okay.
As their concern is the length, but like we know, is if we are going to build as of right, in reality, it's going to be long. But if you see the whole lot is really long, and we will still have a very nice backyard. They will still have that backyard, and the allowable backyard setback is 7 meters. We are proposing 17.44. So it's a very large rear back setback.
What about the side wall height variance?
We lower it by 6 inches, so we can lower the ground floor instead of having ceilings.
Yeah, I wanted to ask what your internal ceiling heights are on the 2 floors.
Yeah, the first floor, we were proposing 10 feet. Now we are 9.6.
Yeah.
And the second floor, 9. What happened is my client doesn't want to have, he wants to have flat ceilings inside. That's why if we do a slope roof, he will have that. Plus.
Okay, so the 7.8, that is a function of the 9.5 on the main floor and 9-foot ceilings on the second floor.
Yes, but we reduce it to 7.64.
Okay, you didn't tell us that. Did you?
Oh, sorry. I think I did.
You hadn't.
You hadn't told us that you had reduced.
Oh, sorry.
You told us the other reductions, but not that one.
Reduction 7.064, which is, yeah, I think we will reduce the ground floor.
What's the height of your basement?
This one here,
it's going to be 8 feet. We have to do, right now it's 7 feet. So I think we are going to do the underpin. So, yeah.
So
depends on the
8 feet in the basement, 9.5 on the main floor, 9 feet on the second floor. And that's as far as you think you should be reasonable to go.
Even if I go 9 foot and 9 foot in the second floor, I will still have a variance there.
Yeah, not as much.
So for the sidewall heights, you provided us with some photographs.
For the what, sorry?
For the sidewall heights?
Yes.
The variance you're requesting. You provided us with some photographs of other properties in the neighborhood. You also provided previous CFA approvals with a height column, but I take it that's the height of the structure. Is there any other examples, or do any of the examples you provided in the photographs, and or are there examples that you could provide us with that in the neighborhood that, or in the vicinity, that have sidewall height as to what you're requesting?
The ones that are flat roof are sidewall height too.
So do they all need variances though? This is what I'm asking. So the photographs that you gave us of the flat roofs.
Yes.
What is the sidewall heights, and are they higher than the bylaw provides?
I don't have that information with the photographs. I have the information of the variances approved before, but that photographs is just to show that in reality there is flat roofs in the
And the
neighborhood.
style of architecture you're arguing exists in the neighborhood.
Yeah.
But you're not certain whether or not, or you can, there's no examples you can provide us with that about sidewall height?
Sidewalls, no, is the, I would say that the ones that are flat roofs are same as side walls. But I wanted to point also, again, remind that if we do slope roof, the height of the building will be higher anyways. So that shadow that they were showing will be more greater because it's higher, the property will be higher. So I thought if we do that flat roof lower, will be more beneficial for them than if we do slope roof higher. So that's how I balance between the bylaw that we are going to request and knowing that the flat roof is an impact for them.
I just note also, Ms. Hayes, that what the applicants provide us, the previous COA approvals and the pictures are not the same thing. They don't match up.
Yeah.
Different animals.
Yeah.
Otherwise, we could figure out what you were asking. Okay, please continue.
Okay, go ahead.
Okay.
I think that is what I say. We know the impact on the shadows, on the gardens around it, but as we say, is if we are going to build as of right, they will have the same impact that what we are proposing.
There's no ability for you to delete the depth variance entirely?
The problem is the second floor, the bedrooms are reduced to not really the width that is available to call bedroom. We will call them another thing because a bed won't fit there.
Certainly the ground floor, there looked to be some ability, if you took off 0.4 or another 0.4, or another even less, 0.3, would just on the ground floor make one of those
if we can do
generous ground floor open plan.
Yes.
That provides, kitchen area, family room, and, a lot of houses you see the family room and the kitchen sort of combined, which...
I agree with you at the ground floor. The second floor is our concern,
okay.
and we could cantilever it.
I also would agree with, as I pointed out in my questioning, that what we're looking at here, aside from the issue of whether it fits in, whether it's the prevailing characters, Mr. Brown pointed out, that we're looking at the increment over what's permitted, which is not, certainly with respect to the depth and the FSI is not significantly over. You're only over 4 meters in the FSI. Okay. Let's see if committee members any further final questions for either the applicant or the neighbors. Okay. So we'll bring it into committee for discussion and decision.
Thank you.
Mr. Chairman, this is a very difficult application because, as you've indicated, the variances are small in number, but I'm taken by Mr. Brown's presentation where he explains that the existing condition is materially different from the neighborhood and that any changes to the bylaw would make that material difference even greater. And I think that's, in some respects, a convincing argument. I also, I want to compliment two people in particular, the applicant, who I thought did a wonderful job of outreach to the community initially. We have many applications that come before us where there's been absolutely no discussion between the applicant and the neighbors. And in this case...
Mr. Nipple here, they're indicating there wasn't.
Well, there was. Well, there's a letter to you and
Copy of a package.
Package, and I think that there was an effort at least to make you aware of what it is they were proposing. And to that extent, I think that's complimentary to you. And the information that's been provided by the appellants has been very helpful. The photographs, which show the implication, Mr. Brown's presentation and the ratepayers' presentation were all very helpful. Having said all that, I agree that the changes to the bylaw are minor, but the one that I am not prepared to support is variance number 6. I do believe it's possible to build within the bylaw requirement for building depth. And on that basis, Mr. Chairman, I'd like to move approval of the application with...
As amended, yeah.
As amended without, yes, as amended, but without approval for variance number 6, which is relative to the building depth. And that decision or that recommendation is conditional upon the right-of-way management cautions that we have before us. So just to clarify, I'm moving the revised application, but not the section dealing with building depth. I believe that the existing building depth in the bylaw should stand and subject to right-of-way management's conditions.
Okay, thank you, Mr. Nippel.
I would second that motion.
Okay. I'm going to make it unanimous. I think that that's a good compromise. If they've taken off point 4, they can take off another readily. I think, you know, there still is an impact, but I think our hands are tied because the impact from the other ones is 4 square meters and the sidewall heights, which go along with the flat roof. So I think when you look at that impact, the impact of what's above the what's permitted is I think it's a good decision. So unanimously approved, modified approval, and thank you. Okay. So we'll now do our last, it's now 12 o'clock, and we're now going to do our last application on the morning agenda, which is item number 19, 126A Glen Road.
Yes.
Yeah, all of the revisions that they had, except the...
It's true, that one they didn't mention till after. She didn't initially mention that.
Yeah, she added during her...
During their, yeah.
7.64.
Yeah, because she... Oh, sure. This is on number 3.
I thought I heard wrong. Thought I heard another address.
That's on number 3, a support letter on number 3. No, on number 3, on number 3. I guess that was an additional one they gave us. Okay, so 216 GLENAYR Road. This is an application to construct a new 2-story detached dwelling. There are 3 variances under the bylaw, and we have on this application before us the materials filed with the application. We have 7 letters of support from 43 Elderwood, 210 GLENAYR, 45 Elderwood, 202 GLENAYR, and 300 GLENAYR, and correspondence and concern from 217 Rosemary Road. And that's all we have. So we don't appear to have the adjacent adjacent properties. Just want to make sure it's not a corner. It is, well.
We don't have this guy.
Right. Okay, would the neighbors please come up to join us at the front table, please?
Good morning. I believe it's still morning. My name is TEY, planner for the owner of the property at 216 GLENAYR Road. The purpose of the application is to construct a new 2-story detached dwelling there.
Could you sit along the side here, please? Thank you. Sorry to interrupt.
No worries. There are 3 variances before you today. One relates to side yard setbacks for both the north and south sides. The others relate to the building length and also FSI. With respect to the first variance, which is the side yards for both the north and south sides, if you look on the screen,
The outline that's in red is the existing dwelling. So you'll note on the north side, it is actually 0.96 of a meter, which is what is being 0.92 of a meter, which is existing. And also, you'll also note as you go further back, the majority of the building itself, or the principal building itself, the two-story element is 17 meters. There's the green / a highlighted area, which is a one-story bump out or a breakfast nook that contributes to the additional building length. So from a...
So that's the portion that's over the, what's permitted?
1.39 over.
Right.
And you'll also note on the north side, it's been set back further than the existing side yard setback of 0.96. So the setback for the bump out, we'll call it the bump out, is 1.72 meters. And this was done consciously to ensure that the additional element or of the length isn't contributing to a feeling of massing towards the property or the rear yards of the properties to the north that front onto Elderwood. You'll also note that the properties that are adjacent to this property that would be impacted by this development or for this house are the properties along Elderwood 45, 43, and 218, all of which have provided support letters in addition to other support letters that have been found provided throughout the area. Once again, there is variances related to, in addition, just to give you another example.
So the key lot people on Elderwood are okay with this?
Yes. Yes. 214, which is the...
In terms of just to be able to better evaluate your presentation, are you the neighbors from Rosemary who wrote the letter? Okay.
So in terms of 214, my client did reach out to them. They didn't have any objections, weren't willing to sign a support letter. They're not here today and did not submit any submissions to this application, so there were no concerns. But if you look on the screen before you, all the areas that have been highlighted in pink, and you'll note the hatch, which is the subject site, all those properties are those properties that are below the side yard setback requirements of 1.2 meters. So this is the existing context in terms of side yard setbacks not meeting the requirements of the bylaw. They're typically in the range of 0.9, sometimes even less, down to 0.75. And you'll also note, if you look at the property at 214, the side yard setback towards the subject site is actually closer than than the existing setbacks of the subject site itself. In addition,
Building on existing foundations, or you're building?
no, this is a brand new home.
So your argument is you want to
Maintain the side yard
In
setbacks.
any event, we haven't heard concerns from the Elderwood neighbors or from the guy at 214.
No, sir. And no concerns from staff.
I assume the people at Rosemary, I assume their concerns appear to be different. I assume the depth, the length, and there was some issue about a pool, which
Yes, sir.
I don't know anything about, but
And I could speak to that, and I could speak to it further after they speak. But basically, there is a pool being proposed at the rear yard. That's not part of this application. No variances are required. Once again, no rear yard setback variance being sought. It's 16 meters that is back from the actual bump out to the rear lot line. This is a one-story element that protrudes beyond the 17-meter mark. And also, in terms of FSI, in terms of FSI of all those properties that have been highlighted in green, and the associated numbers are those numbers that have been approved. So you see FSI as high as 1 times, and you'll note that that's 300 Elderwood, which is immediately 2 properties north of the subject site, and all the properties that are in green are 0.7 times FSIs or greater. So this is from a impact perspective, all those properties that would be impacted have signed off. The portion that is beyond the scope of the bylaw in terms of the building length is a 1-story element. It's separated enough from the rear yard setback line in terms of it's double the setback requirements. So this is a reasonable proposal, and there's no objection from staff.
You indicated that the next door neighbor wasn't willing to sign a letter of support, but they didn't have any concerns.
He did not have any concerns.
Have you made any provision for privacy of the balcony? You have a 2nd-story balcony that sits on top of the breakfast room, right?
There is, and if a screening is required, we'd be glad to provide one, but there was no suggestion from any of the neighbors that...
Neighbors didn't request one?
No.
My concern with the screen is, it is a concern, yes, but when you put them on, it makes the balcony of this size very cramped.
Look, have more mass, correct.
Okay, thank you.
Okay, thank you. Let's hear from the neighbors, and we have I believe you sent 2 letters in. Or do we have just 2 copies? Yeah, I think you have 2 letters.
Yeah, I think there may have been a third one as well. Now, we are longtime residents
Yeah, you want
there.
to state your name for the record?
Yeah, Angelo Shosha, we're the neighbors right behind them on the west side. And our perspective is different from the other neighbors.
Right. Well, not really. The people in Elderwood, if they're impacted by the pool or whatever, adjacent to their backyards. I've read your letters.
Okay, all right.
And I just, what they were proposing here appears to be from other applications where there's like tons of variances. There really isn't a lot of variances here.
Okay.
And they're not that extensive. I just want to hear the impact on you.
Well, the impact on us is already we're practically cooking and eating in each other's kitchen. And you have to be there to see it, okay? Not only that, that's allowing for, I think, 2 or 3 regular 2 regular windows, which are about, I don't know, 5 by 5 and a door. Now you're going to have wall-to-wall glass, okay? And that's what we're going to be facing. However, we're going to be facing it a lot closer to us, okay?
Well, these are normal, so these are Forest Hill lots. You're not looking at a...
I understand.
These are wide, shallow lots. Which
I understand, okay. But what might be a small variance to others, all I'm asking, stick to the bylaws. Stick to the bylaws, okay? To that extent, I would ask that they do that, okay? I've spoken to them, because not only that, so you have the house itself coming closer to us, this massive glass.
Yeah, but we've heard that the only portion that offends the bylaw or exceeds the bylaw is that little bump out on the ground floor. So you have to.
However,
and in terms of whether they should stick to the bylaws, I appreciate in a perfect world, but we have
I'm not asking
3,000 applications in the city of Toronto, in East York. Every year, people want to go a little beyond. That's what the Committee of Adjustment is for. So I want to hear the impact of this little bump out on you compared to what they're.
Let's first finish with the bylaws, okay? What seems to be minor to me, by my calculation, they vary from 9.18% to 10%, which is the floor space alone is equivalent of 2 good-sized bedrooms, okay, which...
It's 30 meters over, right?
Yes, and when you do the calculation, that's 2 bedrooms, okay? So not only that, we're going to be facing a variety of visual impacts here. We're going to, and loss of green space. We're going to lose the space where they're going to put the wood patio, where they're going to put the steps going down to the basement. That's all going to encroach, and although he says the pool will be in the future, the fact of the matter is that it is a huge pool.
We have no jurisdiction, Mr. Scagelo.
Right, but I've spoken to them.
Everyone has to put up. I have a situation, and I'm in a wide, shallow lot with a lot behind me. It's almost all paved, which I guess I could say, and the kid's playing basketball there, who used to be 6 years old and is now 18 years old. And the use issue, it's within their right to put a pool. I'm sure a lot of houses in Forest Hill on your particular block have pools.
Well, with great respect, I would say that I'm asking for is that the bylaws be respected to as they're written. Okay? They have the space. The program can easily be changed. And let's do that. One man's small variance is not another man's small variance. And we use our backyard. When that pool comes along, they're not going to be backyard people. It's just not in the cards. Whereas we have been there a long time. My wife is a die-hard gardener. She spends a lot of time back there, and she would like in our retirement years to be able to continue doing that. So I would ask you that you simply enforce the bylaws. Thank you.
Could I ask you to clarify one thing before you start?
Sure.
On the main floor, you indicated that the building length variance is required because of the pop-out for the breakfast area.
Correct.
But the covered terrace is roofed.
Yes, and that doesn't get counted as part of length. That's not the way the bylaw defines it.
Because it's not enclosed.
That's right.
Okay, but in effect, the building mass is going on beyond the breakfast.
So if you want to speak to the covered porched area, yes, it does extend beyond the breakfast nook, but it has no contributions to FSI or to building length or depth. And if you were to measure that setback from the rear lot line from the edge of that patio, it still would be approximately 14 meters, well in excess of the bylaw requirement. Just to respond to the comments of the neighbor at 217, I guess the only thing that I can say is that we do have this process for a reason, and the test is whether or not it meets the 4 tests of the Planning Act. This application, from a numerical perspective, and most importantly, a qualitative perspective, is more than in line, more than appropriate given the neighborhood's context and what's existing in the area. We have no concerns from the immediate neighbors aside from the neighbor that spoke just recently, and we have no concerns from staff. So this is it's a meritorious application. It does meet the 4 tests, and if there's any questions, I'd be glad to answer them.
Okay, thank you. Any further questions for the neighbors or the applicant, or are we ready for a motion? Okay. Ready for a motion? I just want to ask, would you have any objection to having it tied to plans, just so that it's like
No, sir.
So that you don't use the building length to go straight across, rather than the bump out, and the bump out I notice is...
We have no issues with...
But you'd have to do it, you'd have to find it in the FSI anyway, so...
Correct, but we have no problems with tying it to the site plan.
Although the covered deck does extend beyond, add some massing, it's not included in the formal calculations, and it is open air. I think the other variances that are being proposed are not out of character with the prevailing building size and massing in the neighborhood, and I would move a motion to approve the application, tying it to plans.
Okay, could I make a friendly amendment or suggest a friendly amendment? I don't know that it needs to be tied to all the plans.
No.
I think probably if it was to say it was built substantially in accordance with the site plan by Drew Laszlo, architect, received by the Committee of Adjustment on January the 9th, I don't think it's necessary to tie it to all the other plans, because if he wants to make an internal...
The site plan is fine.
Yeah.
On that basis, I would second the motion.
Okay, and I'm going to make it unanimous. I think, notwithstanding the neighbors are here, and I understand the situation with the pool and it changed, but I think compared to a new build, we're not having a discussion here. I think it's really modest. We've seen a lot of new builds in Forest Hill that sort of try to push the envelope a lot further than this one does. So it's unanimous. Thank you. And we're now, it's now 12:15, and we're adjourned until 1:30 for the afternoon agendas. Thank you. Thank you, neighbors. Okay, the whole time.
We had some excellent submissions today. Some of the people got really good stuff forward.
Yeah, unless you can't talk to us, you can talk to staff. You're not allowed to speak to you. Thank you.
Pardon? The one with the detached garage, that was unfortunate because
two individual applications for reestablishment of. Thanks.